I work with one more outpatient program, and I'm pass it to whoever it is. That's a need for people. I mean,
It kind of goes like this. I don't know what I know what probation is recommending. Whether or not you go forward today, what he's going to do is what he's going to do. So he's either going to do what he's going to do today, or he's going to come back and he's going to file it. So if you want to get it over with today, then it's the same thing. You can ask him for whatever you want. I just probation is okay?
I'm gonna get over it.
Rise, Court of Common Pleas is now in session. The Honorable Eugene Lucci presiding.
May be seated. We're on the record. This is case number 20-CR001124, State of Ohio versus Jasmine Diaz. Ms. Diaz is in court, represented by counsel, Assistant Public Defender James Matthews. On behalf of the Lake County Adult Probation Department is Probation Officer Jamie Crook. Ms. Diaz was here on January 5th, January 25th of 2021. She waived indictment, pled guilty as charged. One count of weapons under disability, felony 3, and a forfeiture specification. I referred her for a pre-sentence investigation and sentenced her on February 22nd, 2021. I adopted a joint recommendation for community control, imposing 2 years of community control sanctions with 4 days in jail, credit for 4 days, abstinence from alcohol and drugs of abuse, periodic screens. She was to obtain her GED, have full-time employment when capable, mental health assessment, take all medicines as prescribed. I told her a violation would result in a prison term of 36 months. I notified her of the potential and consequences for violation of post-release control. I explained the potential for earning credit, substituting community service for costs, and the state block on a motor vehicle registration. The court notes that a few months after I sentenced the defendant, she wanted permission to use a medical marijuana card. She is before the court on a probation violation. The probation violation is documented in an affidavit signed by Probation Officer Crook on September 14th, 2022. She alleges 2 violations, testing positive on August 4th, 2022 with amphetamines and methamphetamine, and a positive again on September 1st, 2022, positive of amphetamine. The court met with counsel and probation in chambers to find out the positions of the parties, and I was informed that after the first positive, the August 4th, a review board hearing was held at the probation department to attempt to obtain compliance. That was August 25th, 2021. Nonetheless, the second violation on September 1st, 2022 occurred. Did I say August 25th, 2021? Well, the review board was August 25th, 2022. I am informed, Ms. Diaz, by your attorney that you wish to give up your right to a probable cause hearing, the purpose of which is for the court to determine whether there's a reason to continue to hold you to answer for the violation. He tells me you wish to give up your right to a final hearing whereby the court would require evidence to its satisfaction that you violated in either or both of the ways alleged in the officer's affidavit, and if I so find, you're entitled to a sentencing hearing. Do you understand these hearing rights?
Yes.
You understand your exposure here is that 36 months in prison that I told you about.
Yes.
Have you discussed with your attorney the waiver of your probable cause hearing, the waiver of your final hearing, and a plea of guilty to the 2 violations?
Yes.
And has he answered all of your questions to your satisfaction about that topic?
Yes.
Do you give up the right to a probable cause hearing?
Yes.
give up the right to a final hearing. What is your plea to the first charge, testing positive on August 4th, 2022 for amphetamines and methamphetamine? Your plea to the second violation, testing positive for amphetamine on September 1st. Court finds that the defendant has knowingly, voluntarily, and intelligently waived her rights to a probable cause and to a final hearing, has entered a plea of guilty to the 2 violations. Court finds the defendant guilty of both violations and determines that they are both non-technical violations because such would be criminal activity by someone even not on community control. Any reason not to proceed to sentencing at this time?
No.
You may go.
Thank you. Your Honor, Ms. Diaz is aware of the probation department's recommendation in this case, and she is hoping that the court will consider allowing her to obtain treatment on an outpatient basis for reasons that she will more fully explain, one of which she said that she is in, I believe, the process of being evicted and does fear that further incarceration would cause her to lose her residence.
Ms. Diaz, the law allows you to say whatever it is you want me to consider before I sentence you. What do you want me to know?
So I'm in the process of being evicted due to my income being on temporary disability. I'm still going through treatment for my back injury, my elbow, and my depression through workers' comp. I'm still my dad's caretaker, which he's fighting bone cancer, and I really don't have nobody but my boyfriend to help me out, and he's already having a lot of issues with getting custody of his child. So I'm the only one right now that can be the person to take care of what I have to take care of on the outside.
So with all of this responsibility on your shoulders, why would you jeopardize shirking that responsibility by committing crime and using drugs?
I'm not going to say that I didn't use no drugs, but the drinks that I did have, somehow, I don't know if I was drugged, but I'm 13 years recovery off of crack cocaine. I would never put meth in my system and become an addict again.
Well,
I do have a problem with drinking.
Were you in a circumstance
At
where
the wrong
somebody
place.
could have spiked your drink?
Yes, wrong place, wrong time, wrong friends. I can say that, and I feel that I was spiked not once but maybe twice because I signed that agreement with probation. And when I came back to probation and she told me I tested positive again, it made me furious inside, but I had to accept it for what it was because...
What were you drinking?
Alcohol.
Okay, you're not allowed to drink alcohol either.
I know. I looked
Now, I
into
gave
A-
you permission to use
the
a marijuana
marijuana.
card,
Yes,
but you hadn't been using that.
No, I haven't. But because I'm going through so much in my life right now, I decided to have a couple drinks and left them unattended. And I did feel sick the times that I did drink. And I spoke to her about it too. And she told me I need to stop being around the peers that I was around. And I looked into AA before I came to see her, before I got locked up on the 15th. I was going to exchange information from Miss Cynthia, which was helping me look for the right program to go to AA. I did my GED. I started my classes. I just want to do the right thing. I don't want anybody to think that I'm trying to play the system. I've been clean too many years to jeopardize my recovery.
considered the record, oral statements made, pre-sentence report, my conference in chambers with defense counsel and probation officer, and the statements of the defendant and the defendant's counsel. I've also considered the overriding purposes of felony sentencing, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender and promote the effective rehabilitation of the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution, along with the public burden. I've considered the separate recommendations of the parties. Court notes that the state did file a motion to terminate community control on September 16th of 2022. I have reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. In using my discretion to determine the most effective way to comply with the purposes and principles of sentencing, I have considered all relevant factors, including the seriousness and the recidivism factors set forth in the statute. There's been no change in seriousness since the original sentencing a year and a half ago. However, with regard to recidivism, recidivism is more likely because of the defendant's two positive tests, despite the intervening review board. There's a pattern of substance abuse, and the offender refuses to take the necessary steps. She knows people, places, and what hanging around that means. She put herself into a position to have her drink spiked. All of that makes recidivism more likely. In terms of making recidivism less likely, the defendant, up until this point, had been doing well on probation, and she has responsibilities that personal and family that she understands has to take precedence, and the court believes that she's willing to address the issue. Accordingly, I am extending your community control by 1 year to a total of 3 years. I'm imposing 74 days in jail with credit for 14 days. The balance of 60 days is deferred until January 15th of 2023, pending completion of an intensive outpatient treatment program. If the intensive outpatient treatment program is not completed by January 15th, 2023, the remaining 60 days will be imposed on January 16th, 2023 at 9:00 a.m. The last 30 days of which you shall enter, participate in, and successfully complete the jail treatment program. All other conditions remain as ordered on February 22nd, 2021. A violation of this order will result in a 36-month prison term. Should you end up in prison, post-release control is optional for a period of up to 2 years. They'll give you rules. You violate their rules, they can return you to prison for up to 9 months for any one violation, and up to 18 months for all violations in the aggregate. All of that time is part of the sentence. Should the violation of post-release control be a new felony, the judge in a new felony case, in addition to sending you to prison on the new case, can send you back to prison on this case for the greater of 1 year or whatever length of time remains unexpired on that potential 2 years of PRC, and all of that time is part of the sentence. Officer Crook January 15th, does that give her enough time to complete the main portion of an intensive outpatient treatment program?
Yes, that should be on.
All right. Ms. Diaz, you understand what's expected of you?
Yes, sir.
All right, so, I'm extending my belief in you and that you can do this, and I'm taking your explanation for what it is. But something like this happens again, there's not going to be an excuse for it. You shouldn't be drinking alcohol because you're not allowed to, and you certainly should not put yourself into a position and hanging around people that can spike your drink. You know that, right? I know you know that.
I do know that.
All right, well, good luck.
rise. This Court of Common Pleas is now in session. The Honorable Eugene A. Lucci presiding.
May be seated. This is case number 21CR000473, State of Ohio versus Shantice M. Wiley. Ms. Wiley is in court, represented by counsel, Assistant Public Defender James Matthews. On behalf of the Lake County Adult Probation Department is Probation Officer Jamie Crook. Ms. Wiley was here on October 15th, 2021. She pled guilty as charged. 1 count of possession of cocaine, felony 5, and a forfeiture specification. I referred her for a pre-sentence investigation. I set sentencing for December 20th, 2021 at 1 o'clock p.m. I set her bond at, or continued her bond at own recognizance. The defendant did not appear for sentencing as scheduled, and the notes from staff was that she was serving a sentence out of Cuyahoga County and being in Edna House, correct? Something like that?
Yeah.
All right. On March 28th, 2022, I sentenced the defendant in this case, adopting a joint recommendation for community control. I placed her on 2 years of community control with 81 days in jail, credit for 21, jail treatment program and aftercare, abstinence screens, 12-step program meetings. She was to obtain her GED, have full employment, have a mental health assessment, 1 doctor, 1 dentist, 1 pharmacy, take all medicines as prescribed, clear up all of the outstanding warrants, and the forfeitures. I told her a violation would result in a prison term of 12 months. I notified her of the potential and consequences for violation of post-release control. I explained the potential of earned credit, substituting community service for costs, and the state block on the motor vehicle registration. The defendant returns to the court on a set of probation violations. The probation violations are documented in affidavits signed by probation officers. The first one signed by Officer David Tompkins on July 27, 2022. He alleges a violation of Rule 8, which requires sobriety. He says that on July 21st, 2022, the defendant tested positive for cocaine. The State of Ohio filed a motion to terminate community control on July 28th, 2022. Then Officer Tompkins filed an addendum on September 20th, 2022, alleging a violation of Rule 3, which requires reporting. He said that the defendant failed to report since July 28th, 2022. He alleges a violation of Rule 1, which requires obedience to the law, alleging that on September 14, 2022, the defendant was arrested by Mentor PD and charged with misdemeanor 1 theft, misdemeanor 2 resisting arrest, and misdemeanor 1 possession of criminal tools. The State of Ohio filed a supplement to the motion to terminate community control on September 21st, 2022. I've met with counsel for the defendant and probation officer in chambers to find out the positions of the parties, and I am informed by your attorney that you wish to give up your right to a probable cause hearing, the purpose of which is for the court to determine whether there's a reason to continue to hold you to answer for the violations. He tells me you wish to give up your right to a final hearing whereby the court would require evidence to its satisfaction. And if I so find, you're entitled to a sentencing hearing. And I further learned in chambers that the Mentor Municipal Court charges have been resolved by your plea of guilty, and you are serving a 90-day sentence, correct? So, when was that imposed? Just a few days ago?
Yes.
All right. So you understand your maximum exposure here is that 12 months in prison I told you about?
Yes.
And have you discussed with your attorney the waiver of these hearing rights and a plea of guilty to the 3 violations and any other options you may have at this point?
Yes.
And he's answered all your questions about that?
Yes.
So do you give up the right to a probable cause hearing?
Yes.
Do you give up the right to a final hearing?
Yes.
And what is your plea to the first violation, testing positive for cocaine?
Guilty.
And your plea to the second violation, failing to report?
Guilty.
And the third violation, committing more crimes?
Guilty.
Court finds that the defendant has knowingly, voluntarily, and intelligently waived her rights to a probable cause and final hearing and has entered a plea of guilty to 3 violations. Court finds the defendant guilty of all 3 violations and determines that they are all non-technical violations, as the positive cocaine and the other crimes are crimes. You don't have to be on probation for that to be a crime. The failure to report is evidence and demonstrates an unwillingness and an inability to be amenable to community control. Any reason not to proceed to sentencing?
No, Your Honor.
Go ahead.
Thank you. Your Honor, Ms. Wiley would like to thank the court for the opportunity she was given on community control. However, at this point, she does not wish to remain under supervision. She has never been to prison before and would ask that the court impose the minimum 6-month term under the law. Thank you.
And Ms. Wiley, do you have anything to say?
I'm thankful that you gave me a chance, and I just want to get this over and done with.
I've considered the record, oral statements made, pre-sentence report, my conference in chambers with counsel and probation, and the statements of the defendant and the defendant's counsel. I've also considered the overriding purposes of felony sentencing pursuant to revised code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender and promote the effective rehabilitation of the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution along with the public burden. I've considered the joint recommendation of the parties for a prison term. I have reasonably calculated this sentence to achieve the 2 overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders, in using my discretion to determine the most effective way to comply with the purposes and principles of sentencing. I have considered all relevant factors, including the seriousness and the recidivism factors set forth in revised code 2929.12. There's been no change in seriousness factors since the original sentencing, In terms of recidivism, there is a previous criminal history as reflected in the pre-sentence investigation. There's been a rehabilitation failure. She's failed to respond to community control. There's a pattern of substance abuse, and the offender refuses to acknowledge a problem, accept treatment, or apply treatment tools previously given to her in at least the jail treatment program, but she was also at Edna House. The defendant has committed more crimes and has failed to report. All of that indicates to the court an abandonment of the purposes of community control, and that the defendant is no longer amenable to any available community control sanction. Accordingly, I am terminating your community control sanction, and I am imposing prison for 6 months, concurrent with the municipal sentence, with credit for 95 days already served. Upon your release, you could be on post-release control, PRC, for a period of up to 2 years, where they can return you administratively for up to 3 months, even for one violation. Should the violation of PRC be a new felony, in addition to going to prison on the new case, you can go back to prison on this case for another year, and all of that time is part of the sentence. Anything further?
No, you're right. Thanks.
Jamie, anything further? All right, good luck. We're
Thank you.
adjourned.
Yeah, they're over there.
All rise. Court of Common Pleas is now in session. The Honorable Eugene A. Lucci presiding.
May be seated. These are case numbers 20 CR 000183 and 20 CR 000329. Both cases, State of Ohio versus Christian A. Wright. Mr. Wright is in court, represented by counsel, Assistant Public Defender Conchetta Regazione. On behalf of the Lake County Adult Probation Department is Officer Jamie Crook. The defendant was here on June 8th of 2020. He waived indictment on both cases and pled guilty as charged. In the 183 case, count 1, robbery of a bank, felony 2, a Senate Bill 201 qualifying offense. And in the 329 case, count 1, robbery of a bank, a felony of the 3rd degree. I referred him for a pre-sentence investigation and report, set sentencing, and I continued his bond in the 183 as reset and set bond in the 329 case. I sentenced the defendant on July 6th of 2020 to 3 years of community control sanctions, each case concurrent. On the 329 case, I imposed 194 days in jail, credit for 134 days. And on the 183 case, I imposed 134 days in jail with credit for 134 days. The jail was concurrent. He used to do the jail treatment program, abstinence from alcohol and drugs of abuse, periodic screens to monitor his compliance, full-time employment or school. He was to have an initial mental health assessment and follow all recommendations, take all medicines as prescribed, perform 400 hours of community service, have no contact with the victim banks or any of their employees. I told them a violation would result in a prison term of 8 years on the 183 case and 36 months on the 329 case, consecutive, for a total prison of 11 to 15 years. I notified him of the mandatory nature of post-release control, explained the 8% credit, substituting community service for costs, and a state block on the motor vehicle registration. The defendant returns to the court on a set of probation violations. The probation violations are documented in affidavits signed by Probation Officer Jillian Gibson. The first one is April 29th of 2021. She alleges 3 violations of Rule 8, which requires sobriety. She says that the defendant self-reported alcohol use on September 23rd of 2020. She says that on September 24th, 2020, the defendant submitted a urine screen that tested positive for marijuana. And then on April 22nd, 2021, the defendant submitted a urine screen that tested positive for marijuana. The State of Ohio filed a motion to terminate community control on April 29th of 2021. And the officer filed an addendum on May 17th of 2021 and says that a violation of Rule 3, which requires reporting, she says the defendant failed to report on May 13th of 2021. The State of Ohio filed a motion to terminate community control on May 18th of 2021. I've met with defense counsel and probation officer in chambers and found out that when the affidavit was filed, May 17th of 2021, the defendant had missed one visit on May 13th. I learned in chambers that it's been ever since that the defendant did not report until he was finally apprehended. The State of Ohio filed a supplement, I think I mentioned that on May 18th of 2021, to terminate community control. Mr. Wright, your attorney tells me that you wish to give up your right to a probable cause hearing, the purpose of which is for the court to determine whether there's a reason to continue to hold you to answer for the violations. She tells me you wish to give up the right to a final hearing whereby the court would require evidence to its satisfaction that you violated in 1, 2, 3, or all 4 ways alleged in the officer's affidavits, and if I so find, you're entitled to a sentencing hearing. Do you understand these hearing rights?
No.
Why don't you understand them?
One moment, please.
So I did speak with my client. He did indicate to me that he wants to waive the hearings that admit the violations.
All right. So you understand the hearing rights, the probable cause hearing, the final hearing?
Yes.
And do you give up the right to a probable cause hearing?
Yes.
Do you give up the right to a final hearing?
Yes.
And what is your plea to the first violation using alcohol on September 23rd of 2020?
Guilty.
The second violation, testing positive for marijuana on September 24th of 2020.
Guilty.
The third violation, testing positive for marijuana on April 22nd, 2021 with that sample.
Guilty.
And failing to report ever since May 13th of 2021.
That's the part I just don't remember. I don't remember.
What do you mean you don't remember?
I don't remember her saying, like, you messed up. She told me to finish the program that I did.
No. What I'm talking about is you have...
I understand. Yeah, I understand. I didn't report. I didn't see her, but she told me to finish the program to get help because I told her I was suicidal. Like, I really just don't understand, like, all of this. So she told me to finish the program, and I did. More counseling, the IOP, outpatient thing. No, I finished it. It just didn't matter at that point. No, I just want to get this over with. Like, I don't. She told me to get help, and that's what I did.
Well,
I didn't report it though. Oh, that's what the question is. I didn't report it, sir.
you remember at sentencing, the prosecutor wanted me to send you to prison for 5 years.
See, that's the thing. My life was just moving so fast.
No,
right now.
are you telling me you don't remember anything that happened?
I do. It's just stupidity, man. Like I really, it wasn't worth it.
What wasn't worth it? What are you talking about?
So, Your Honor, I think my client's confusing the sentencing portion with this plea portion. So I did explain to him that at the time of sentencing, which will be after the plea, immediately, I assume, he would then have the opportunity to explain everything that was going on at the time and why these violations occurred.
Well, I was asking what your plea was on failing to report to probation as ordered and required ever since May 13th of 2021.
Guilty.
Court finds that the defendant has knowingly, voluntarily, and intelligently waived his rights to a probable cause and to a final hearing, has entered a plea of guilty to the 4 violations. Court finds the defendant guilty of all 4 violations and determines that the alcohol violation is a technical violation, but that the 2 marijuana usage charges and the failure to report are non-technical violations. First off, because the positive marijuanas would be a crime if committed by someone who is not on probation, but that the failure to report for the better part of 15 months, 14 months, shows that the defendant is not amenable to an available community control sanction and has abandoned the community control that I placed upon him at the time of the original sentencing. So the court finds the defendant guilty on all 4 violations. Any reason not to proceed to sentencing?
No, Your Honor.
Go ahead.
Thank you, Your Honor. Your Honor, I would ask this court to take some things into consideration in making the determination regarding whether Mr. Wright does remain amenable to community control sanctions. And on his behalf, I would ask the court to find that he is still amenable to community control sanctions. In speaking with Mr. Wright, he recognizes that he really took a situation that it was a bad situation. He did violate probation with the alcohol and the marijuana usage. However, by not reporting then after that for such a period of time, he really did create a much bigger, more serious situation, and he is remorseful for that. What he expressed to me is that he has a lot of anxiety issues. He needed to address those. He did follow up with more counseling. As he was expressing previously, he was told to do so by probation. He has indicated to me that he did follow through with that, but looking back, it's really evident that he needed something more intense and more significant. I understand that NeoCap is not something available for this type of an offense, but I would ask the court to consider as a punishment in this case some significant local jail time followed by residential treatment as a treatment portion, and my office could work to locate a bed for him so that following some significant jail he could go straight into a residential facility and remain on community control. He's really done a lot of reflection and realized that he really did mess up. Unfortunately, he let his anxiety and his fear about this situation overcome him, and so then he just tried to avoid it and bury his head in the sand, and he is very remorseful for that. He recognizes...
He's not telling me any of this, though. You're saying that he told me he doesn't remember the prosecutor asking for 5 years in prison. He doesn't remember this, he doesn't remember that. He's putting all of this aside. I cut him as big a break as anyone could ever expect anywhere.
Yes, Your Honor.
2 bank robberies, and I put him on probation.
Yes. That
And then he doesn't report for 15 months? And you want me to now put him on probation and keep him on probation when the treatment facility that we have won't even take him because it's such a high-level crime?
Yes, Your Honor, that is what Mr. Wright is requesting, recognizing.
I need to hear it from him. I need to hear it from him because all I've heard from him is, well, I don't remember this, and I don't remember the prosecutor asking for that. Even at the plea, the prosecutor said that they would cap their request for prison at 5 years. All I heard him say was, well, they told me to go do more counseling, I did it, and I'm done.
Okay. Well, I can turn it over to my client.
Let me hear
to address
what
the
you have to
court.
say.
Do I have to stand?
No, you can stay seated. But I want to hear how you excuse this conduct. By the way, I don't care about the alcohol. I don't care about the marijuana. I care about not reporting because reporting is accountability. And you have not submitted yourself to the accountability I required. Why did you not submit to the accountability? Make yourself accountable for what you were doing.
Honestly, at the time, I really didn't look at it as.
At what time? At the 15-month period of time, or at a particular day within that 15-month period of time? This is 15 months that you did not report. At what point did you decide, well, screw this judge, I'm never going to report again, and I don't care I robbed 2 banks. The people out there don't care that I robbed 2 banks and that I'm letting this judge is letting me loose on them. Now I understand, I gave you this break because of your lack of criminal history. You're a first offender, and I treated this as a one-off. Well, as a two-off, because you did rob 2 banks on different occasions. So, I'm accountable too. So, my accountability is to hold you accountable. Tell me.
At the time, back when you did give me the second chance, I was very grateful. But honestly, Your Honor, I was very much immature. So when I got out of jail, I found myself doing well. I was happy. I was actually doing well with probation, but I got overwhelmed, honestly, with just my decisions. I kept thinking about every day, literally every day, the decisions that I made, because I wasn't raised like this. Like, it really did get to be a lot to think that I did what I did over about $1,400, and I wasn't raised like that.
You know,
and it was just stupidity. And
let me stop you here for a second, because I'm about to, my mind is thinking remorse. However, I've been told by 2 higher courts that I have no ability to judge remorse. So you have to give me a different reason, because I'm questioning my own ability with people sitting in front of me to judge remorse. I'm having a difficult time. So I have to put remorse out of this, because I can't figure out whether you're remorseful or not. Because I've had people give me this speech and then tell me off right after they've given me this speech, and it makes me question whether anyone can ever tell remorse, let alone the Court of Appeals or a Supreme Court justice reading a blank transcript, whether they can judge remorse. So let's talk about reality. Other than remorse, what's going on here?
Stupidity.
Stupidity.
During the 15 months, I don't even know what I was thinking of, but I just couldn't take it anymore for 2022, and I literally called the cops.
Then how do I know this won't happen again? So
This is not
you
right.
were stupid, and now you're no longer stupid. You were immature, and you're no longer immature. So when did you mature, and when did you not become unstupid?
This year.
This year.
Yes,
When?
sir. I called the cops on myself, and
When?
3 weeks ago, I called the cops on myself and told
Is
them
that why they arrested you?
they not to pick me up. I called them on myself.
When you called them, did they arrest you on the
Yes.
warrant that I issued?
Yes, Your Honor.
Okay. So that's when you saw the light.
Yeah.
3 weeks ago. Why did you see the light 3 weeks ago? I need specifics here, because I don't know what's in your head. But I'm going to be judged by people that are telling me I have to figure out what's in your head. Let me hear from your mother. Ma'am, can you step up to the podium?
Your Honor.
And do you feel well today?
Yes.
Okay. I can't understand people when they're in masks,
Oh,
and I
I'm
read
sorry.
lips.
Okay, I'm sorry,
Okay,
but
go
I'm
ahead.
a school teacher and germs is, so, but I take it off. You
Well, I don't
wanna
like
take it all the
germs
way off?
either. You can
Is
take
this
it off.
okay?
I just need to see your lips.
Oh, okay, I'm sorry, okay.
My wife tells me I'm hard of hearing.
Okay, Judge, Christian is my son, I'm his mom, of course, but his 4th grade teacher told me years ago he needed meds. And I was like, well, no, I'm not medicating him. But as time went on, and he does. Now, to answer your question about why he just turned himself in, because reality hit Christian. he was applying and applying for jobs. I kept trying to get him a job. He kept turning them down because this felony is on him. And one thing I can't agree with him, he was not raised like that. Like I said, I'm a school teacher. His dad was a computer programmer. And it's like after his dad died, everything just went. He was a star on the football team. He graduated high school. He had almost had offers for scholarships, but the GPA wasn't matching. But just make a long story short, he was not raised that way. And I believe because he wasn't raised that way, he was raised in the church and everything, his conscience was eating him up. I'm glad he turned himself in because he couldn't sleep. Then I couldn't sleep because he would come bothering me, you know, wanting to talk at 3, 4 in the morning. I had to get up a couple hours. So his conscience was really, really getting to him. And I said the same thing that you said. It wasn't the marijuana and the drink, the liquor. It was you did not show up and face what you did. You had to keep going back to your parole officer, because I was here when you told him that. And I'm like, why aren't you going back? You know? But I believe, and see how immature he was. I'm like, okay, he hide now. He go to the grocery store with me. He put his hoodie on, hide. And I'm saying, that show you how immature he is, because if you really, really wanted him, you guys could have put right up to the house and got him. I couldn't believe that he turned himself in. I was laying in the bed the next morning getting ready for work, and he called and said, I'm in Lyndhurst. I turned myself in at 4 something in the morning. I'm glad of that because, like I said, the way he was raised. And I always told him, let your conscience be your guide, you know. And, you know, he kept threatening suicide, and he's not well at all. And I just heard you say the facility won't accept him because of the felony, but he needs help. He needs medicine.
Can I interrupt you a second? I ordered a mental health evaluation and by a psychiatrist, and first off, was that done?
Was what done?
The mental health assessment.
I don't know what
Jamie,
going to discuss.
I ordered a mental health assessment here.
He had been working with more counseling while he was on probation, but he was never fully compliant with them.
Okay, well that's part of the problem.
Oh, he was
because
compliant with them?
You say that maybe he needs to be on some medication, I ordered him to go to a psychiatrist in order to have him evaluated to see if he does, and he didn't do that.
Oh, see, I didn't know that, sir.
I was doing more counseling, and that was for drug and alcohol use. I used to speak to the lead guy and ask him, can I get further help? But that was a drug and alcohol program.
Well, a mental health assessment is different than a drug and alcohol program. Those are drug and alcohol counselors. I wanted you to see a medical doctor to see whether you need to be on some form of medication. Maybe you don't, maybe you do. Your mother seems to think that you do, and I don't know. And that's why I ordered it. And when I order something, I'm not doing this just to exercise my speech. I do it because you have to do this. This is all part of the rehabilitation program. And while we're on that, I ordered you to perform 400 hours of community service. You said you can't get a job because of the felony conviction, but you can certainly volunteer your work. Where do you live?
South Euclid, Ohio.
They don't have anybody in need there through the churches or anything else where you can perform community service. How many hours of community service did you actually perform so far?
0, John.
0. And you've been on probation for 2 years and coming up on 3 months.
Ms. Gibson, at first, my original, she wanted me to complete the program, and then she said just do things step by step and then move on to that.
Well, see, Working is important. I ordered you to get a job. I can understand if you can't get a job. We probably don't have enough jobs out there. That's not what I'm hearing, but we maybe not have enough jobs out there. But you can certainly perform community service. You know that old saying, what is it, idle minds, idle hands? Okay, if I keep you busy, I figure that you'd less likely to be sitting around smoking pot and drinking alcohol. If I keep you busy, it engages your mind, and maybe you can figure out, well, maybe there is a job that I can do despite the felony conviction. I mean, you brought the conviction on yourself, and I don't make the law here. The law says that can't be expunged. We don't expunge bank robberies. And so you brought that on yourself. And I am not denying you anything because I have no control over that. That is not within my authority. But within my authority is to keep you busy and to keep you on the right track and to give you tools. And that's what I tried to do, but you haven't been doing for 2 years and 2.5, almost 3 months, what I told you to do. And you haven't reported for over 15 months.
Can I say something?
Yes, continue.
And
Sorry for interrupting you,
just
but
so I could get some sleep, maybe I'm wrong, I would give him leave PM so he wouldn't come up and bother me, just so I could get some rest. And I really believe that, he has a problem. He does. I don't know if it was a chemical imbalance and,
well, that's why I wanted a physician to look at him.
And he did go to a physician, and I don't know what happened. He didn't really tell me. I got him a primary care doctor.
Well, what
He has
normally happens is when I order a mental health assessment by a psychiatrist or a clinical psychologist, the individual probationer tells the probation officer, this is the person that I am going to fulfill my obligation for my sentence, for my punishment, because this is all part of the punishment, but it's really rehabilitation.
And he didn't go. See, I didn't know that.
Yeah.
I would have
And then he provides a report. The doctor provides a report to the probation department so that they have proof of what's recommended. And so that I have coverage too, because he committed a violent crime.
Right.
And I told him that you have to see a mental health professional, and if he doesn't, the mental health professional says, this man needs no medication or anything, then I've done my job. And if he says he does need medication and he doesn't get it, then I can order him to do that. But if he doesn't do what I tell him to do, then he doesn't want to be on a program. That tells me he wants to go to prison.
Thing to say, I was raised, God's will be done, Judge, and whatever your decision is today, it's in God's will. And I don't mean to get religious in your court, but that's how I feel now, because Christian was raised totally different.
And you were here for the sentencing, correct?
Yes, I was, and I heard everything. And I'm not well, I'm a brittle diabetic, and let his will be done.
All right, thank you.
You're welcome, and thank you.
So, Mr. Wright, they filed the 3 positives, the alcohol and the 2 marijuanas and the failure to report. I know you did the jail treatment program because you didn't have any choice to do that on your own. I just kept you incarcerated until it was done. You didn't have the initial psychiatric or psychological consultation that I ordered. You didn't perform any of the community service. I'm assuming you've had no contact with the victim banks or any of their employees, right? Because that's an easy thing to comply with.
I would never do that again.
So, the probation department could have filed an addendum that said you didn't have the mental health assessment and you didn't perform any of the community service hours. That pretty much means the only thing you complied with is staying away from the banks and doing the jail treatment program, which you had no choice not to do. I'm having a difficult time believing that you didn't understand the gift that I gave you. How can you not? There was a prosecutor there, Miss Winter, and she was saying 5 years in prison for this man. And I overrode, and by the way, there was a presumption for prison. I was expected to send you to prison. But we don't have computers do sentencing. We have human beings, and I saw in you, being a first offender, that you would be one who, this is just 2 mistakes, close in time, and that you would do what you were told to do. I know you weren't raised this way, because I had the forensic psychologist examine you, but he's not a clinical psychologist. He doesn't prescribe medications. So the law expected me to send you to prison for a minimum of 2 years. And you were represented by a different public defender than the one who is here today. But she had to have explained to you, after I gave you community control rather than prison, my God, you dodged a bullet there. Didn't she tell you that? Or something like that. I don't know what word she would have used.
She did.
Okay, so you knew the break that I cut you. I'm shocked that you didn't jump for joy and say, I will do everything, the few things that this judge has ordered me to do. Get a mental health evaluation. What's the harm in getting that? You can't possibly be hurt by having a mental health violation by a psychiatrist or psychologist of your choosing. People do that all the time. Getting your fingers dirty in the soil, performing community service. How can you possibly be harmed by doing that? A little work doesn't hurt anybody. You wanted to say something.
With the mental health thing, I completely don't remember that part. 100% sure. I don't.
Okay, didn't the prosecutor send you a copy of my order? Don't they, Ms. Ragazione, do you expect your clients to just remember everything the judge says in court and not send them a copy of the order?
Your Honor, and I can't speak for the attorney who represented him at the time, but I do know that typically our policy is once the entry is put on to send a copy of that to the client. And if they're at the jail, then we put it in their office.
All right. So you're telling me you didn't get a copy of the order?
I remember exactly the stipulations you gave, but I do not remember the mental health thing at all.
You don't remember the mental health thing?
That's the only one. I remember
And
community service, everything else.
did Jamie probation go over all of the requirements with him and have him sign?
Yes, Your Honor, those were gone over with him on July 10th of 2020, and the mental health evaluation after here is on the streets.
Well, here's what I'm going to do. I'm going to continue this hearing. When we reconvene, Ms. Ragazione, you can present what you want to present. But the problem is, this was being treated on my schedule as a normal probation violation, but it's a Reagan-Tokes. And if I have to sentence the defendant, it requires the time of a Reagan-Tokes sentencing, because it requires all of the advisements. So I'm going to continue this hearing. We will reconvene in a few weeks when we can get it back on the schedule, because I'm starting a murder trial Friday that's going to occupy me full-time for the next 2+ weeks. Anything? This is case number 22 CR 000962. State of Ohio versus Carla M. Ferrona. Is that your name?
Yes, it is.
Ms. Ferrona is in court, represented by counsel. Assistant Public Defender Conchetta Regazione, representing the State of Ohio, is Assistant Prosecuting Attorney Amy Alesci. Before we start this hearing, the last one threw me off schedule, and at 10:45, I've got a couple of doctors on the line on a WebEx on a competency hearing that the defendant requested, and so I have to do that because they've got another WebEx after that. So wherever we are, we'll just interrupt it, pretty much stay where you are, and then we'll just do the WebEx. Tony, where am I seeing this? You'll set it up. Okay. All right, Ms. Ferrona, you are charged in an information filed by the Lake County Prosecuting Attorney on September 26th, 2022. One count of possession of cocaine, a felony of the 5th degree, a Division B offense, and a forfeiture specification for contraband and instrumentalities. It's my understanding you wish to give up your right of indictment and plead guilty as charged, and further that you wish to waive any pre-sentence investigation and report and proceed directly to sentencing with a joint recommendation to the court of 10 months in prison. Is that your understanding as to what you want to do here today?
It is, Your Honor.
So you understand you have the right to have the Lake County Grand Jury consider the evidence as presented by the prosecuting attorney, and for the grand jury to determine the charge or charges. In doing so, they could land on the same charge we have here. They could charge you with something more, something less, or nothing at all. The point is, it's totally up to the grand jury. Do you understand that?
I do, Your Honor.
You understand that this offense carries a maximum penalty of 12 months in prison and a maximum fine of $2,500?
I do, Your Honor.
You understand it carries an optional maximum driver's license suspension of 5 years, up to 5 years.
I do, Your Honor.
And you understand that you would forfeit all contraband and instrumentalities.
I do, Your Honor.
And have you discussed this decision about waiving indictment with your attorney?
I have, Your Honor.
And has she answered all of your questions to your satisfaction?
Yes, Your Honor.
Going to hand you a document. Do you give up the right of indictment?
Yes, I do.
Going to hand you a document called Waiver of Indictment. Make sure you've read it. Make sure you understand what it says. Make sure you agree with what it says. And if you sign it only because that's what you want to do.
And Your Honor, I did go over this document with Ms. Verona prior to the start of the hearing. I do believe that she understands it and she is willing to sign it.
That's not going to work.
I've witnessed the defendant, her attorney, sign the waiver of indictment and sign the document as well. May I approach?
Yes? I will make the waiver of indictment part of the record in the case. So before I can accept your plea of guilty to this possession of cocaine charge, I have to determine if you know and understand the rights you are giving up, the consequences of a guilty plea, and that you are entering the plea of guilty of your own free will. How old are you?
I do. I'm from 45, Your Honor.
How far did you go in school?
Graduation, some
And
college.
do you have the ability to read, write, and understand the English language?
Yes, Your Honor.
Do you hold any kind of state-issued occupational license or certification?
I do not.
Are you a U.S. citizen?
Yes, I am.
Are you currently under the influence of any drugs, alcohol,
I am
or
not.
medication? Have you taken any within the last 48 hours?
I have not.
Have you ever been treated for mental illness?
Yes, I have.
Tell me about that.
I have been diagnosed since the age of 17 with multiple different things. The lastly being the ADHD, PTSD, borderline personality, and just extreme abuse, basically, is what it is. I'm coming to terms with it. I'm learning about it. Yet and still, I still have a lot of dissociation things. It's a lot. It's a long fight.
This all stemmed from abuse as a child?
Starting in childhood on, Your Honor.
Okay.
So, you know, it's been a fight, but I didn't know about it for a long time. So yes, and the thing is I do stay sober for a while, but then it could be a door that's locked from the inside. Now that I'm learning about a lot of things, it could flash me back and I'm gone. So no, I'm not perfect, but I am fighting. It was almost 3 years I stayed sober this time, you know. So I'm kind of proud of myself, and I'm not going to stop. I'm not going to stop my fight, you know,
Okay.
for life.
That's good.
Yeah. thank
So, have you received a copy of the charge here, the information?
you. Yes, I have, Your Honor.
And did you read it?
I did, Your
You
Honor.
understand it?
Yes, Your Honor.
Did you discuss it with your attorney?
Yes, I did.
Did she answer all of your questions to your satisfaction about the charge?
Yes, Your Honor.
Do you agree that it describes what you did?
Yeah, absolutely. I
And do you
do
wish to
that.
plead guilty to the charge and the forfeiture specification?
Absolutely.
I've been handed a 4-page document called Written Plea of Guilty. You probably went over this document with your attorney before you started the hearing, is that
Yes,
correct?
I did,
And did
Your
you read this document?
Yeah, we went over it.
Okay, you went over it word for word?
I mean, basically, yeah, pretty much, right?
Your Honor, I didn't read it to her word for word. I did summarize the content.
Yeah.
Okay,
Pretty much.
well, we will be going over essentially the content during this hearing.
Okay.
And I do
And-
have another copy that I can place in front of her as well during the hearing.
That's fine.
Sure.
The written document is totally optional. Very few courts in the state use that. It's our local culture that we do use that, but I go over everything that is in there anyway.
Sure, Your Honor.
So, I'm going to go over the charge you are proposing to plead guilty to so that we are all on the same page. Count 1 says that on May 25th, 2022, in the city of Wickliffe in Lake County, Ohio, you knowingly obtained, possessed, or used cocaine, a Schedule II controlled substance. That's called possession of cocaine. It's a felony of the 5th degree. It's in violation of Revised Code Section 2925.11, and Division B controls in determining whether I impose a prison term. Do you understand the charge?
I do, Your Honor.
And is that the charge you wish to plead guilty to?
Yes, Your Honor.
And attached to it is a forfeiture specification that says during the commission of the offense, you had in your possession contraband and instrumentalities, being the cocaine and pipes, and on that basis you would forfeit those items. Do you understand that?
I do, Your Honor.
And do you wish to plead guilty to that?
Yes, Your Honor.
So you understand if you plead guilty, you are admitting you committed the crime.
Yes, Your Honor, it was mine.
And you understand if you had any defense, you give up that defense by pleading guilty.
Yes.
You understand by pleading guilty, you are giving the court the power to sentence you immediately, and pursuant to your joint recommendation, I will.
Yes, Your Honor.
And you understand that any rulings previously made by this or any other court on this case prior to this moment would not be appealable because you're pleading guilty at this time.
Yes, Your Honor.
And you understand that if I go along with the joint recommendation, that makes it an agreed sentence, and that can never be appealed.
That's fine. Yes, Your Honor.
You have certain trial rights. I'm going to go through them one at a time because you are giving these up by pleading guilty. So I need to make sure that you know and understand you have these rights and that you're voluntarily giving them up
Okay.
before I can accept your plea. So you don't have to plead guilty. You have a right to have a trial to determine whether you're guilty of any crime. That trial would automatically be by a jury in this court unless you decided you wanted a non-jury trial. A non-jury trial is a trial where you want the judge not only to make all of the decisions throughout the case, but you want the judge to make the ultimate factual determination in the case whether the state has proved your guilt beyond a reasonable doubt. Do you understand that?
I do, Your Honor.
You understand that a trial gives you the ability to test every aspect of the state's case, both factual and legal.
Yes, Your Honor.
You understand that with a jury trial, the jury makes the decision, I don't, whether the state has proved its case against you, and furthermore, it takes all 12 jurors to agree that you're guilty before it's even possible for you to be convicted. Do you understand all that?
Yes, Your Honor.
The state of Ohio is required to prove your guilt beyond a reasonable doubt. If the state failed to prove even one essential element of the particular charge beyond a reasonable doubt, you could not be convicted of that particular crime. Your plea of guilty provides the court the entire factual and legal basis upon which to convict you and sentence you, and by your plea, you are relieving the state of any obligation to prove anything, let alone prove it beyond a reasonable doubt. Do you understand that?
I do.
You have the right to confront your accusers, meaning to have your attorney question all of the state's witnesses under oath in front of the judge and jury. Do you understand that?
I do.
You have the right to use the subpoena power of the court to compel witnesses you need to come here to testify for you, especially witnesses who are reluctant to come to court, out of state, or incarcerated someplace. I can get them here for you. Do you understand that?
Yes, Your Honor.
You have the right to tell your side of what occurred here and testify in your own defense, or you could refuse to testify. It's one way or the other, but it is your choice. No one can compel you to testify if you did not want to, and if you chose not to testify, that could not be used against you to prove that you were guilty. The prosecutor could not comment on your silence to infer you're guilty, and the jurors, only jurors would be selected who tell me under oath during jury selection that they will uphold that right, would be seated on your jury. Do you understand that?
I do, Your Honor.
You understand if you were not pleading guilty today, you would always be represented by an attorney throughout this case free of charge to you?
Yes, Your
You
Honor.
understand if you were not pleading guilty today, you could appeal any of my decisions, you could appeal the jury's verdict, you would have a free transcript typed up of everything said or done in this court so you can demonstrate to a higher court any mistakes here to get those mistakes corrected, and a free attorney to handle that appeal. You understand all that?
I do, Your Honor.
You understand a plea of guilty is a complete admission of guilt.
Yes, Your Honor.
Do you voluntarily give up all the rights that I just explained to you and wish to have this court accept your plea of guilty to one count of possession of cocaine, felony 5, and the forfeiture specification?
Yes, Your Honor, I do.
And Tony, set it up for the WebEx. So we are going to break right here. I don't know how long the hearing's going to take. Maybe 10 minutes, something like that.
Yeah. No.
I'm going to get the file.
All rise. Chris?
Yes, it's perfect.
Thank you.
Good visual, good audio.
Thank you.
you. You're welcome.
Are we able to call them quickly on your phone just to talk to Justin for 30 seconds before the hearing? If we ask them to have their phone number?
Is there a phone number that we can call Justin at quickly before the start of the hearing?
I'm sorry?
Is there a phone number that we can call Justin at quickly before the start of the hearing?
Sure.
Thank you.
Let's see. So this is going to be, call the main North Coast number, so 330-467-7131. And then it'll be extension 2171.
Thank you.
I think people just can use your phone.
That'd be great.
please now in session. The Honorable Eugene A. Lucci presiding.
May be seated. We're on the record. This is case number 21, CR 001576, State of Ohio versus Justin M. Edwards. The matter is before the court on a competency issue. A motion was filed by the defense to review the order for involuntary medication at North Coast Behavioral Health Care. At a previous hearing on August 8th, I determined that the defendant should go to North Coast as he was not competent and can be restored. And the court received a report from North Coast on August 23rd, 2022. And the opinion was that he was not able to participate in treatment planning, lacks any insight related to his mental illness and the need for medication, lacks capacity to give informed consent, with treatment that can be expected to improve his thought process and improve reality testing. The physician at North Coast requested permission to give him medication against his objection and listed a proposed treatment involving 5 medications. And the defense has, on September 13th, 2022, requested a review, and I granted the request, and with the concurrence of the defense, having Mr. Edwards and various professionals at North Coast Behavioral Health Care to participate by remote video and audio. So, who do we have here from North Coast? I can't understand people when they're wearing masks, and I look at their lips to see who's talking. So, give me that again.
Ashley Vanderkar.
Okay, Ashley. How do you spell your last name?
Vandercar.
Okay. And what is your position at North Coast Behavioral?
I'm a forensic psychiatrist.
All right. And then seated at the table there with you is Justin Edwards, correct?
Yes, sir.
Mr. Edwards, can you hear me? All right, you've understood what I've said so far?
Yes, sir.
Okay, and then I want to note that two attorneys are here on your behalf from the Public Defender's Office, Lauren Tuttle and Billy Kilmeyer. Also present on behalf of the State of Ohio is Assistant Prosecuting Attorney Alexandra Cutts.
Thank you.
So let me start off with Ms. Vanderkar. What are your basic qualifications, your degree, and how long have you been doing this?
So, I began my career as an attorney, so I had a JD, and then after that, I attended medical school at the University of Miami. I then did a psychiatry residency for 4 years, and then I did a forensic psychiatry fellowship at Case Western. I'm board certified in both psychiatry as well as forensic psychiatry, and I've been working as a competency restoration attending as well as doing competence to stand trial evaluations at North Coast for a little bit over a year.
All right. And are you familiar with the report that I spoke of earlier that was generated August 23rd of this year and provided to the court?
Yes, sir. So that was the second opinion that was predicated on the report that I had submitted on August 16th, both regarding competency and my first opinion requesting medication over objection.
All right. And so the second report, was that authored by you or Dr. Stankowski? No, that was Dr. Ahmed.
So the first report on August 16th was authored by me. The second report on the 23rd was authored by Dr. Ahmed. Because for fourth opinion, we have a rotating system where when someone requests medication over objection, the CCO office, Dr. Stankowski, assigns a second psychiatrist to go in and do an independent review. And in this case, that was Dr. Ahmed, and thus he wrote the opinion that was signed on 8/23.
All right. And then in his opinion, he concurred completely with yours and then agrees with and put forth the proposed treatment regimen, correct?
Yes, sir.
All right. So let me ask first the state's attorney, Ms. Cutts, do you have other questions for Dr. Vanderkar?
I do, Your Honor. I also, if I may, was going to ask the court to take judicial notice of the indictment filed on March 4th of 2022, indicating that Mr. Edwards has been indicted on 2 counts, one being resisting arrest, a felony of the 4th degree, and 1 count being assaulting a police dog or horse, a misdemeanor of the 2nd degree. And then parties have agreed, I have a joint exhibit 1 of the evaluations completed, the one by Dr. Vanderkar as well as Dr. Ahmed, that we would stipulate to the authenticity and admissibility of those reports. I also wanted to mention to the court on August 31st of 2022, an initial judgment entry was done where the defendant was found to be not competent by stipulation, and then that was initially where the forced medication was granted, but now we're reviewing that aspect. So he has been found not competent at this stage. Should I just...
Yes, go ahead.
Dr. Vanderkar, just to be clear, I know you've kind of talked about your educational background, things of that nature. I know it's obvious, but where are you currently employed?
North Coast Behavioral Health Care.
And what is the purpose when people go to North Coast Behavioral Health Care?
So there's a variety of different reasons that people can come to North Coast Behavioral Health Care. We're predominantly a forensic hospital. Around 80% of the people that come here are here as a result of a court order, typically for treatment. There is also a subset of people who come to North Coast Behavioral Health Care for a 20-day inpatient competence to stand trial evaluation, and that was what initially brought Mr. Edwards here.
And have you conducted, prior to Mr. Edwards, other competency or capacity to refuse medication evaluations?
Yes, ma'am.
And I know you've mentioned Mr. Edwards, just for purposes of identification, is he in the same room with you at the end of the table?
Yes.
The record can reflect an identification of the defendant, Your Honor.
Yes.
When did you start interacting, interviewing, evaluating, meeting Mr. Edwards?
So my first evaluation was with Mr. Edwards on August 10th, immediately upon his arrival to North Coast Behavioral Health Care. And when he came here, we had, I believe it was plus or minus a few minutes, a 2-hour initial interview after he arrived here.
And you were made aware of that he is there on both a felony charge as well as a misdemeanor charge?
Correct.
When you, is it fair to say besides in addition to the August 10th of 2022, that you had met or interacted with Mr. Edwards more than that one day?
Yes. So if you're looking at the time of the evaluation report, when that was written, and that was authored on the 16th, I had interacted with him both during his initial evaluation for 2 hours on the 10th, as well as again on the 11th, the 15th, and the 16th. The first 3 of those meetings were related to me being an evaluator. The last was actually when I was working at the hospital overnight doing MDOD work, which is on-call work, when I was called to address a code in response to damage that he had done to his room.
Okay. So we will definitely get to that, but I wanted to check, during these times, the times you met for the evaluation as well as this on-call aspect, did you or other staff members observe any signs of mental illness regarding Mr. Edwards?
Yes. So Mr. Edwards, both during the initial interview as well as ones thereafter, presented as overtly paranoid, as well as what we would call hypomanic. So the paranoia was manifested both in terms of when he first walked into the interview room, his frequent glances around the room, as well as the description of a variety of delusional ideas, so fixed false beliefs, including those related to a conspiracy from the court system, both as to his charges as well as defective and fraudulent indictments. Those delusional beliefs morphed during the hospitalization because the day after he was admitted, he was diagnosed with COVID, and he began to develop an idea that he had been purposely infected with COVID in order to toll his speedy trial rights.
Okay, so please correct me if I'm wrong. So you saw paranoia, delusions, you indicated as hypermanic. Would you also consider, would it be appropriate to say he had disorganized thoughts?
Yes, so his thoughts were both perseverative and tangential, and it would lapse into periods of disorganization.
In your interactions with Mr. Edwards, did he believe, or does he believe that he has any mental illness?
So when I asked Mr. Edwards whether he has a mental illness, in general the response that I have heard has been no. There have been times that he has mentioned receptors in the brain. There's also been times that he has mentioned having PTSD with some aspect of a personality disorder. But when I've attempted to redirect him to the delusional nature of his thoughts or the psychosis, he has told me that he does not have a psychotic disorder.
So would it be fair to say that he has poor insight or judgment based on what you've seen and interacted with him?
Yes.
Were there any altercations that you are aware of that Mr. Edwards had with other patients or individuals at the hospital?
Yes. So Mr. Edwards has had 3 what we call code violets during his hospitalization. The first code violet was on August 13th when he was walking the halls shouting about the fact that he had been purposely infected with COVID-19 and that he wanted to be discharged, and he was throwing items out into the hall. As a result of that, there was an altercation with the patient had to be sent out to the emergency room for an evaluation, and Mr. Edwards received an injectable medication of Zyprexa, which is an antipsychotic, as well as Benadryl. That was the first co-pilot on August 13th. Second co-pilot was early in the morning of August 16th, after nursing heard some very loud noises in his room, and they proceeded to go in there and find that he had removed the drywall from all around the electrical socket, as well as extensive amounts of drywall from around the window to the room, and broken the marble ceiling in the bathroom, and there were large shards of marble. As a result of that, I was on call. I offered him medications. He initially declined medications. Due to the level of concern about safety, he was instructed that he would be given forced medications for the emergency if he didn't take them, and at that point he did accept medications. That was the second co-pilot. The third co-pilot was on August 23rd, which was a couple hours after we had had a meeting where he was discussing his belief that the judge was part of a conspiracy, complaints were defective. He had been...
It's false information. I didn't claim that against the judge.
He had been called another patient in the racial slur. He had a tray that was thrown at him, and
Mr. Edwards, I'll give you the chance to testify. Don't interrupt Dr. Vanderkar.
Yes, sir.
Continue, ma'am.
at that point he had a tray that was thrown at him, and he was also punched multiple times by another patient. He was offered medication again on medication and declined. However, as there was no acute emergency at that point, he was not given medications. Those were the three codes that happened.
What diagnoses, if any, does Mr. Edwards have?
So Mr. Edwards has an unspecified schizophrenia spectrum and other psychotic disorder, and that would be based on the purity of thought disorganization, the delusional ideas, the elevated mood. The diagnosis is listed as unspecified as opposed to schizophrenia or bipolar disorder with psychotic symptoms due to the lack of collateral information, and that Mr. Edwards had described to me that he had previously been in the federal system for competency restoration, and stated that he had a diagnosis of a delusional disorder while there, and that he had been restored to competency on medications. However, he has declined to release any records from his previous treatment, and as a result of a lack of collateral regarding the length of symptoms and whether they've been present with or without mood symptoms, can't at this point distinguish between the various psychotic disorders.
So whether the disorders are the delusional disorder, the bipolar, or the schizophrenia, would treatment for all of those still include antipsychotic medication?
They would, yes, ma'am.
Other than the emergency dispersed medication on August 13th, and then on August 16th when he did agree to take medication as opposed to having it involuntarily given, has he been taking medications at North Coast?
Yes. So on the 31st, the journal entry for medication over objection was obtained. And there had actually been a close call earlier that day regarding whether to engage in emergent medications, but there was no co-pilot. But after the journal entry was received, Mr. Edwards was initially ordered to start on Invega, which is an antipsychotic medication, pursuant to the medication over objection journal entry. He declined. He was told that it would be given forcibly if he did not take it based on the court order. At that point, he asked to speak with me. I spoke with him. He requested that he be started on Abilify, which is a different antipsychotic medication, stating that that had worked for him in the past. He was thus on August 31st started on oral Abilify, which was increased on September 3rd, and then September 6th, he received a long-acting injectable of Abilify Maintainer. He has been taking that because it's a long-acting injectable that's been given once a month, although he has continued to state that he does not have a mental illness, that
better form. Before August 31st, was he agreeing to take medications?
No.
Does he believe that he needs medication?
No.
When you were assessing him regarding his capacity to refuse medication, is it fair to say you look at chart any information you received from the Lake County Court as well as the multiple interviews that you did with him?
Yes.
And did you render an opinion regarding Mr. Edwards' capacity to refuse medication?
Yes, it was my opinion that based on his lack of insight as well as his refusal of medications, that he lacked capacity to refuse the recommended medications.
And is that opinion to a reasonable degree of medical certainty?
Yes, it is.
And do you have a proposed course of treatment for Mr. Edwards?
Yes, so there was a checkbox list that I believe was submitted to the court that I had filled out. And in it included a variety of different potential antipsychotic medications, as well as mood stabilizing medications and medications for side effects. The reason that a number of medications were included is that it can be difficult to tell from the beginning which one is going to be the most effective. At present, Mr. Edwards is on a Abilify Maintainer, 400 milligrams every 4 weeks. Depending on the level of response, that would then be switched to a different antipsychotic medication, such as the Invega Sustenna or a Haldol. It's also possible that if this current mood elevation continues in the pacing, that there could be the need for a mood stabilizing agent such as Depakote to be added onto that. If there are side effects such as what we call EPS or movement stiffness, we could then potentially need to add anticholinergic agents such as Progentin or Ativan or Benadryl.
Objection, that would put me in the hospital. Sure. That's a version.
Is the administration of medication substantially likely to render Mr. Edwards competent to stand trial?
I think that there is a substantial likelihood of Mr. Edwards being restored within the statutory period if given medications, yes.
You had made reference to at least one side effect, movement stiffness. Are there other potential side effects that can go with these medications?
Yes, so these medications have a long list of potential side effects. In general, you have 2 different groups of antipsychotic medications. You have the older antipsychotics, like Haldol, Prolixin. Those predominantly have movement side effects. They can result in tardive dyskinesia, extrapyramidal symptoms like stiffness. The newer ones are more prone to cause issues such as weight gain, increased cholesterol. All of them also potentially have cardiovascular impact. The mood stabilizing medications can have impact on the liver. There's also another long list of potential side effects. However, with any of these medications, when they are recommended because of the fact that the risks associated with the person's disorder and their thought disorder are far outweighed by the likely benefits associated with the medications. Also, there's monitoring that goes on for these various side effects, such as for liver function. There's blood work that is taken for the cardiovascular risks, when there are medications in someone that we have concern for that. We do other types of monitoring, including vitals, and in some cases, EKGs. We also do an AIDS test, which looks for tremors and tics, and make modifications to the treatment regimen if there begin to be concerns about those side effects.
In addition to those changes, are there medications or treatments available to combat some of these side effects?
Yes.
Looking at the potential of a trial, would any of these side effects significantly interfere with Mr. Edwards' ability to assist his counsel in conducting a trial and his defense, therefore ensuring a fair trial?
No, in fact, the goal would be to restore him to competence on these medications, and thus facilitate and allow his thoughts to be organized and his speech to manifest that organization in a manner that would allow him to participate with his attorney to engage in trial.
And in your opinion, are there any less intrusive alternatives or options available that would achieve substantially the same results?
No.
And is the administration of drugs medically appropriate and in Mr. Edwards' best medical interest in light of his medical condition?
Yes.
We have a brief moment, Your Honor.
Yes.
Your Honor, I have no additional questions at this time.
Doctor, is this treatment regimen with these various drugs, including the Haldol, something that is a fairly common experience for North Coast Behavioral?
Yes. So our patients, if they are here for competency restoration, except for when they first get here, they are almost all on antipsychotic medications, and many of them also on mood stabilizing and other medications to facilitate their treatment.
And with the Haldol, do you find that the dyskinesia, well, it's tardive dyskinesia, so you may not recognize it while the person is still there, correct?
So that is correct. And so Mr. Edwards is on Abilify, which is one of the newer ones. But with any of them, the risk of TD is something that we monitor for. In general, people that develop TD, it resolves when the antipsychotic is either reduced, stopped, or they're switched to a different antipsychotic. But there is a very small subset that does not happen, and that is one of the risks.
Okay, so with the Haldol and you're monitoring, do you titrate that down? Because doesn't a sudden cessation of it also precipitate the dyskinesia?
I'm sorry, doesn't the what this precipitate?
Doesn't a sudden cessation of the drug precipitate the onset of dyskinesia? Doesn't it have to be titrated down?
So if we were to take someone off of Haldol, usually we would switch them to one of the newer antipsychotic medications. And depending on which one it would either be a cross titration, where we would slowly reduce the Haldol dose while increasing the dose of the new medication, or with some of them, it would be a direct conversion, where they are put on the exact same milligram dosage of the new one that they were on for the Haldol.
Okay, so Abilify is one of the alternatives to Haldol.
That is correct, and he is currently on the Abilify maintain.
All right, and so Mr. Edwards has some experience with the Abilify and had been taking it on his own when he was not incarcerated, correct?
I do not know whether he had taken it when he was not incarcerated, but he did tell me that he took it when he was in the federal system for competency restoration.
Okay, and he generally is in favor of Abilify, is that correct?
In terms of the medication choices, yes.
Okay, all right, Cross?
Thank you, Your Honor.
Mr. Kilmeyer?
And can I have a short recess with my attorney, just a minute or two?
Sure.
Judge, we have a phone number that we can call directly on,
Okay.
as long as that's okay with
All
the
right,
folks
so they're
at
going to
Wells.
call you by phone to have a private conversation, and I will have them step out into the hallway to do that, so I don't have to empty the 8 or so people that are in the courtroom. And I'm not sure how we pause the video.
They muted on their end the last time we made the call, Judge.
They did what?
They muted on their end.
Okay, all right. So the officers that are there can mute the audio on this, and you're going to step out in the hallway and do it? Okay. All right, Mr. Edwards, they will be calling you there. You can put it on the table.
we had another hearing that's scheduled at 11:30. As parties here for this, we were not anticipating that this hearing would take this extended amount of time. Hello?
Yes, we hear you.
Okay.
It all depends upon what the defense intends to do. Mr. Kilmeyer.
I have a number of questions for Dr. Vanderkar and we'll want Justin to testify.
Okay, so I think we will have to continue the hearing then, because I could expect it to go probably another hour, and I don't want to throw you off on your other obligations. But the first time I can get this back on the schedule will be in a few weeks, because I start a murder trial Friday. It's going to take the better part of 2.5 weeks. What's that? Did you hear what he said?
Yes, and this is what we spoke about on the call. Your Honor, we're prepared to go forward on the argument, but we just be allowed to take, or we just be ordered to take the bill by for the sake of expediency for this hearing.
So, and all the rest would be appropriate?
No, we would argue that the order only included the bill of
Okay, but they're asking for Invega, Prolixin, Risperdal, Zyprexa, and any other drugs needed to counteract the effects.
We would ask that if those become necessary, another request be made for the course, if this non-course medication is premature, is implying that they're wanting to give them a
Okay.
In addition to that, we can argue this by memorandum as well.
All right. Well, and this is the great thing about remote hearings. Somebody can just cut you off on the other side, and the judge has no control over the hearing. For all those proponents out there that we should do even jury trials by remote, we will continue the matter. You can file a memorandum, because by the time I get this back on the schedule, you'd have time to prepare and file a memorandum, and possibly the prosecutor will have time to respond. Apparently today my schedule is not my own. All right, anything further?
Not at this time, Your Honor. Thank you.
All right, we're adjourned on this one. And let's swap out attorneys and go back to the other one. Okay, we're back on the record on 22 CR 000962, State versus Carla Ferrona. And I know exactly where I left off because I marked it. So, Ms. Ferrona, are you now or were you at the time of this offense on May 25th of 2022 been on parole, post-release control, community control sanctions, or probation to any court anywhere?
I was not, Your Honor.
And have you ever been to prison before?
Yes, I have, Your Honor.
How many times?
3 times, Your Honor.
Have I ever sent you to prison?
Yes, and I'm not proud of this fact.
Pardon?
And yes, you have, and I'm not proud of this fact.
Okay. How many times have I sent you to prison?
You sent me 1 time, Your Honor.
And who sent you the other 2 times?
Through Cleveland court system and then through college. He's retired now, Your Honor.
Which county?
This county.
This county?
Did. Yes, Your Honor.
Mitrovich, Gibson?
So I was
Collins?
gonna say Collins.
Collins,
Judge
okay.
Collins did. Yes, Your Honor. I want you to know why I was down there. I did go ahead and I went ahead and I got my CDCA. It's not certified with the stamp, you know, and I did work through it. I came home, I got a job, I got a car, I got a house, and I was doing really good. I didn't think I needed AA, and I didn't think I needed to keep up with mental health things, which is where I faltered. I thought I was healed because I got a certificate, and I was working, I was making $18 an hour. You know, I was doing good for the first time in my life, and I thought the abuse that I'd been through and everything else would just go out the window. This is where I fell down and I faltered, you know.
So on your previous commitments to prison, were they all drugs?
Yes, Your Honor, I am an addict.
And you were on probation before going to prison?
I've done everything, Your Honor, and like I said, I'm not proud of it, nor did I want sobriety for a very long time. You know, nor did I look into a lot of things. I'm guilty. I'm guilty of relapsing. I'm guilty of falling down.
All right, so you understand by pleading guilty, you are voluntarily giving up your liberty for whatever length of time I sentence you to prison, and if I agree with the 10 months, that's an agreed sentence, and as I said earlier, you can't complain about that.
Yes, Your Honor, and I'm not proud of what I did, like I said. You know, I fell down, but that's it.
So you understand that I can give you 12 months in prison.
Yes, Your Honor.
You understand that I can fine you up to $2,500.
Yes, I do, Your Honor.
You understand I can suspend your driver's license for up to 5 years.
I do, Your Honor.
You understand you would forfeit all the items of contraband and instrumentalities.
I do, Your Honor.
You understand that you're disqualified, both state and federal, from purchasing, owning, possessing, or using firearms or ammunition for firearms.
Yes, Your Honor.
You understand that while in prison, you may be eligible for, be offered, and be able to earn some credit, capped usually at 8% of time to be served or a certain number of days according to their regulations, by engaging in educational, vocational, or rehabilitational programming offered to you for that purpose.
Yes, Your Honor.
You understand that upon your release from prison, you could be on post-release control, PRC, in the discretion of the Ohio Adult Parole Authority for a period of up to 2 years. They give you rules, you violate their rules, they can return you to prison for up to 1/2 of the original sentence I give you for all violations together. And if your violation of PRC is a new felony, in addition to going to prison on the new case, you can go back to prison on this case for another year. All of that extra time is all part of the sentence already. Do you understand that?
I do, Your Honor.
Do you understand I will order you to reimburse the government the cost of confinement, any supervision, any treatment, and court costs?
I do, Your Honor.
And you understand the cost of confinement also includes the transportation costs?
No, I didn't, but I do now.
Now, when they put you in a car to bring you here, take you back, take you to prison,
Yeah.
all of that gets added in to the cost of confinement.
Probably more than gas money, huh?
The gas would cost you more than what they assess.
No.
So you're getting a deal. You understand I will enter a judgment against you for the cost of prosecution.
Yes, Your Honor.
and that a failure to pay any fine or costs in full can result in the state blocking your motor vehicle license plates until they are paid in full.
Yes, Your Honor.
You understand all the potential penalties?
I do, Your Honor.
Any question at all as to what can happen to you as a result of your plea of guilty today?
No, Your Honor, I do not.
You understand no promises have been made by the court, the prosecutor, your attorney, or anyone as to what I will do when it comes time for sentencing,
Yes, Your Honor.
and that I don't have to go along with the joint recommendation.
I do, Your Honor.
So I can still give you 12 months.
Yes, Your Honor.
Has anyone else made any kind of promises or threats to you in order to get you to plead guilty?
Absolutely not, Your Honor.
Are you entering the plea freely and voluntarily?
Yes, Your Honor.
Have you told your attorney everything you considered important in the case?
No. Oh, yes.
Yeah, you didn't hold back anything from her?
No.
Have you had enough time to discuss what you're doing in this case with your attorney?
Yes, Your Honor.
Although this may be your attorney's recommendation for you to plead guilty to this charge, is this your own decision and voluntary act to do so?
Yes, Your Honor.
Has your attorney done everything you've asked her to do for you in this case?
Yes, Your Honor.
Are you completely satisfied with the legal representation provided by Concetta Ragazione?
Yes, Your Honor.
And Ms. Alessi, what would the facts show if the case went to trial?
If this case proceeded to trial, the state would prove beyond a reasonable doubt that the defendant knowingly possessed cocaine. Specifically on May 25th, 2022 in Lake County, state of Ohio, officers initiated a traffic stop on a vehicle that had been reported stolen. The defendant was identified as the driver and sole occupant of the vehicle. In conducting a search of the vehicle, officers located suspected cocaine in pipes. The cocaine was sent to the Lake County Crime Lab and tested positive for cocaine, a Schedule II controlled substance. And just so the court's aware in regards to the stolen vehicle, that case was resolved in Village Municipal Court as unauthorized use of a motor vehicle. Thank you.
And Ms. Verona, did you hear and understand everything the prosecutor just said?
Yes, I did.
Everything she said true?
Yes.
What is your plea to one count of possession of cocaine, felony 5?
That was my cocaine, Your Honor, and I do say I'm guilty of that.
And your plea to the forfeiture specification?
Absolutely, guilty.
Guilty?
Yes, Your Honor.
All right, I'm going to hand you the written plea of guilty document we talked about earlier. Make sure you've read it, make sure you understand what it says, make sure you agree with what it says, and if you sign it only because that's what you want to do. I've made no changes to that document since you last saw it.
And Your Honor, I did go over this document with Ms. Verona prior to the start of the hearing. She did indicate she understands it and she is willing to sign it.
I witnessed the defendant and her attorney sign their plea of guilty in open court. I signed it as well. May I approach?
Yes. Court will sign the judgment entry at the end of the document and make the written plea of guilty part of the record in the case. Record should reflect that defendant Carla M. Verona was here with Attorney Concetta Ragazione in open court. I informed Ms. Verona of all of her constitutional rights. She's made a knowing, intelligent, and voluntary waiver of those rights. I find she understands the nature of the charge, the effect of the plea, as well as the maximum penalty which can be imposed. Finding it to be knowing, intelligent, and voluntary, I accept her plea and find her guilty as charged. Count 1, possession of cocaine, felony 5, revised code 2925.11, and the forfeiture specification attached to it. Defendant has waived any pre-sentence investigation. The court will proceed to sentencing. And what is the credit to date?
42 days, Your Honor.
You agree?
Yes, Your Honor.
And the joint recommendation is for 10 months in prison.
Yes, Your Honor.
Yes, Your Honor.
And Ms. Verona, you understand the joint recommendation?
I do, Your Honor.
And are you requesting that the court adopt that as an agreed sentence?
Yes, Your Honor.
All right. Do you have anything else to say?
No, Your Honor, but through the time, the last couple years that I was sober and I was home, I was able to see what life is like. I did it for the first time, I can't tell you, since I was probably a teen, held a job, had
counsel doesn't need to say anything, right?
No, Your Honor.
No, Your Honor, thank you.
Unless you want to be heard. You don't want to be heard, do you?
No, Your Honor, I mean, we're just asking the court to adopt the judgment.
I know, you don't want to talk me out of it.
Yes, Your Honor, that's correct.
I've considered the record, the oral statements made, history with the court as disclosed during the hearing, the statements of the defendant, defendant's counsel. I've considered the overriding purposes of felony sentencing pursuant to Revised Code 2929.11. I've considered the need for incapacitation, deterrence, rehabilitation, and restitution along with the public burden. I've considered the joint recommendation of the parties. I have reasonably calculated the sentence to achieve the overriding purposes and to be commensurate with and not demeaning, and to be consistent. I've considered the relevant factors, including seriousness and recidivism in 2929.12. The court believes that the joint recommendation is appropriate. The court will adopt the joint recommendation. Therefore, it is an agreed sentence of 10 months in prison with credit for 42 days. Contraband and instrumentality are forfeited. Court's already advised the defendant about the post-release control and the potential for earning credit. Defendants to pay the costs of prosecution and confinement. Anything further from the state?
No, Your Honor, thank you.
Defense?
No, Your Honor, thank you.
Mr. Rona, good luck.
Thank you, Your Honor, and not to be saying the same, but I hope I don't see you again.
Me too. We're adjourned.
Second, take this? Okay, thank you.
Rise.
Run the record, this is case number 22 CR 000072, State of Ohio versus Antoine F. Wynn. Mr. Wynn is in court, represented by counsel, Assistant Public Defenders Mary Springer and Billy Kilmeyer. Representing the State of Ohio is Assistant Prosecuting Attorney Amy Alessi. The defendant was indicted on May 16th, 2022. Count 1, felonious assault, a felony of the second degree with a firearm specification a 1.5 year and a 4.5 year firearm specification, and also a repeat violent offender specification, and also a forfeiture specification for a Taurus revolver and a Ruger 9mm pistol. Count 2, having weapons while under disability, felony 3. Which, with the same 2 firearm specifications and the same forfeiture specification. Count 3, having weapons while under disability, felony 3, with the same firearm and forfeiture specifications. Count 4, inducing panic, felony 4, with the same 2 firearm specifications and the same forfeiture specification. The defendant was evaluated for competency, and he was before the court on July 25th, 2022. He, at that time, court learned that the defendant fired his attorney 2 times on that day. He wanted him back, and then counsel decided that he no longer wanted to represent the defendant because of deep distrust. I appointed a public defender to represent the defendant, and I set it for a competency hearing and arraignment in about 2 to 3 weeks. The court had 2 opinions that the defendant was competent, both by the court's forensic psychologist, Dr. Rinsberg, and North Coast Behavioral Health Care. Defendant was before the court on August 22nd for arraignment. Not guilty was entered and bond was set. The matter is before the court for pre-trial. And Ms. Alessi, would you explain to me what the state contends occurred here?
Yes, Your Honor. The defendant was at United Skates in Wickliffe at a child's birthday party. Upon exiting United Skates, he had some verbal altercation with another male that was on scene. While the defendant went to his vehicle, pulled the vehicle around to the front of the United States, and continued to have this verbal altercation with another male. The defendant then began shooting at the other male. He fired 5 rounds from the Ruger 9mm and 3 rounds from the .38 Special. The defendant then ran from the scene. He ran into another building, instructed that they called police, and then continued to run off scene up onto Euclid Ave, where police then apprehended him. Upon Mirandizing and questioning the defendant, he admitted to shooting the firearms, to having 2 firearms, and to also shooting first on that day.
And does the state have an offer?
Yes, Your Honor. And I should add, by way of the facts, United States, as a result of the shooting, did have to close down for the remainder of the day. While the shooting was occurring, all of the people inside, including numerous children, were kind of sequestered to the center of the dance floor, and then they ended up canceling the rest of their birthday parties that afternoon, which is why there was an inducing panic as well, and that the defendant was on parole at the time of the offense and under disability for numerous offenses as well. And for a offer of a plea agreement, the state made the following offer to defense counsel: to plead to felonious assault, a felony of the 2nd degree, with the attached 54-month specification, and having weapons while under disability, a felony of the 3rd degree with the attached forfeiture specification. If resolved by way of plea agreement with a joint sentencing recommendation, the state agreed to recommend 12.5 years in prison. Applying Reagan-Tobes, there'd be an additional indefinite prison term of 1 to 4 years. And if the defendant did not wish to join in the state's sentencing recommendation, the defendant could request any available sentence, and in that case, the state would recommend a sentence greater than 12.5 years, and it would also be the state's position that those counts, the felonious assault and having weapons under disability, would not merge for purposes of sentencing.
So your offer is to count 1 and count 2?
Yes, Your Honor. With just the 154-month specification on count 1.
And the forfeiture specification on count 2, is that what?
Yes, Your Honor.
The case is set for a jury trial on November 1st. Are there any impediments to going forward on November 1st?
Not from the state side, Your Honor, no.
Defense?
Not from the defense's side either, Your Honor. We are aware of a motion that the defendant filed pro se on September 16th, asking that the public defender's office be withdrawn. If we're able to address that today, and if we do remain on the case, we would be prepared to proceed on the scheduled trial date with Mr. Wynn.
Okay. Well, let's address that today. Mr. Wynn, you are asking that is there any attorney that would ever satisfy you in this case?
Yes, I don't want to. I can stand up.
You don't have to stand up.
Yeah, I don't want to fire her. I just want her to file a motion because, like, when I got caught, I did not. Okay, look, I just want her to file a motion for criminal rule 29 for the acquittal of count 1 of felonious assault due to insufficient evidence. Because, Your Honor, when I got caught, Your Honor, I never said that I shot first. My exact words.
Well, hold on. Anything you say can be used against you.
I know, Your Honor.
Okay, so don't say anything. Let me just tell you that a Rule 29 motion is made at trial.
Okay.
I have to see the evidence.
Okay.
Because just because the prosecutor said this is what she believes the evidence will be, doesn't mean that that's what the evidence will be.
Okay.
So I have to see the evidence, how it plays out,
Okay.
and consider a Rule 29 motion at the time.
Okay.
And it would be after the state rests.
Okay, yeah. that's
Or after they make an opening
yeah,
statement if they
I didn't want to
so
fight her.
fail.
I just wanted her to file a motion, and I wanted to file a motion to suppress all the evidence that they have in my statements from talking to the police. I was incompetent in my statements when I was talking to the police, so I ain't know. So I want her to file a motion to suppress my statements when I was talking to the police, and a request for acquittal of the count 1 to the indictment due to insufficient evidence, felonious assault due to insufficient evidence.
Okay. I hesitate to ask this. How is he incompetent? Did the police make you incompetent?
You said what?
Did the police make you incompetent?
No, when I got caught, my lawyer right here filed a motion for the incompetence, and then that's why I never got charged, because I was in here for 8 months due to I was waiting on the evaluation, labeled incompetent, waiting on the evaluation. That's why I was in here for this long. My case would have been over with. They labeled me incompetent, even though I kept.
Who labeled you incompetent?
You did, and and when I was they.
Your Honor, I believe when Mr. Nguyen came before the court with Mr. Shorn, at one point in time, I think based on Dr. Winsberg's report, they were prepared to stipulate to that report some of Mr. Nguyen's behavior, I think, concerned the court. And so the court asked that a second opinion be made from North Coast. And so that
Okay, I didn't declare him incompetent or labeled him incompetent. I wanted him reviewed for competency.
Yeah, but that's
Yes,
when my paper said I was incompetent. So
What paper said you were incompetent?
I got a paper saying I was waiting to go to North Coast to be evaluated. So that means
To be evaluated.
Yeah, but I don't. But like off the record, I just wanted to.
No, nothing's off the record here.
Well,
It's
not
all
off the
being
record.
recorded.
I just wanted to file these motions due to insufficient evidence. They have no victims or any witnesses, and I have witness on my behalf.
Well,
saying
I understand.
I was the
I understand
one
your
in hurt.
statement
I'm the victim in
about
this.
victims.
I'm the victim in this.
Hold on. I understand what you mean by a victimless crime. Nobody was hit, right?
Yeah,
Okay, but
I'm the victim.
And you'll have an opportunity to present your side of the case. But first things first. I never labeled you incompetent. When I label somebody incompetent, that means I declare them incompetent and I order them restored to competency based upon a particular treatment plan to do that. It never got to that point because both reports that I have from the professionals in 2 different institutions said that you were competent, and I agreed with them that you were competent, and I declared you to be competent to stand trial.
Your Honor, if I could I present the judgment entry to the court that Mr. Nguyen has been
Yeah, let me
referencing?
see it.
Thank you.
And if I may, the court did find the defendant incompetent in that JE dated April 5th, 2022, and ordered the defendant be sent to North Coast to be restored.
Oh,
And at that point, I think, I don't know if it was due to bed availability or whatever the reason was, North Coast ended up sending a doctor here to evaluate Mr. Nguyen instead of him going to North Coast.
okay.
At which time they rendered an opinion that he was competent as well. We had another hearing.
That's what I
Defense and I
had here.
stipulated to the contents of that report.
I have it. So they didn't have to restore him?
North Coast found him competent, and so that there was no need for any restoration.
Okay.
He never left our facility.
All right. Was this done at the time that he fired his lawyer twice? That same hearing?
No, I think this was back in April, Your Honor, with after Dr. Rinsberg's opinion was rendered.
Okay.
Then the court ordered that North Coast do the evaluation, so some time period passed until, I think, July.
And North Coast, I wanted it done here and ordered North Coast
You ordered
to...
that he be sent to North Coast, and I don't, for whatever reason, I don't know if North Coast didn't have bed availability.
Okay, so
did
they
a-
wanted to send the doctor here.
Yeah, so
to
the
do it.
doctor came here to evaluate him.
Okay.
Yeah, it was not your direction that North Coast.
All right,
necessarily.
it's coming back to me now. All right, so the defenses that you're talking about can be raised at the trial, and the trial is set for November 1st. You're ready for trial on November 1st?
Yes, Your Honor.
Okay. So barring any unforeseen circumstances, that's what it'll be. And so does the defense specifically reject the state's offer?
Yeah, yes, I reject.
Okay, anything further?
No, Your Honor, thank you.
There was just one other thing that I wanted to address from the defendant's motion to ask the public defender's office be withdrawn. He stated that he didn't have discovery. I just want the court to be aware that that has been fully provided to him,
All right.
and we've been able to go over it.
Okay, you agree, you got the discovery, correct? Okay,
Thank you, Your Honor.
all right, we're adjourned.
Capristo.
So we'll just set dates today, okay? And that's what we have to do. Can I see this one? Do you have a card? Is he going to expect us to go with it? Or you can wait till we got pre-sentence report. I think you guys are for the waiver in. I never saw that.
No, there's no waiver.
There's no waiver?
I have a copy of one from that one.
Okay. No, I'm sorry. Is that all the process? Yep. Okay, I was just waiting for this to resolve that.
All rise, this quarter county, please, is now in session. The Honorable Eugene, presiding.
May be seated. We're on the record. This is case number 22 CR 000211, State of Ohio versus Ronald A. Capristo Jr. Mr. Capristo is in court, represented by counsel. Attorney John Dowell, representing the State of Ohio, is Assistant Prosecuting Attorney Sarah Haranek. The defendant was indicted on June 3rd, 2022. Total of 5 counts. Count 1 is kidnapping, felony of the first degree. Count 2, kidnapping, a felony of the first degree. And it appears to be just another definition of count 1. Count 3, abduction, felony 3. And that looks to me to be a lesser included. To count 1. Count 4, domestic violence, felony 3. And count 5, domestic violence, felony 3. And those are alleged to have occurred on 2 different dates. The case is before the court on a pretrial. The defendant was arraigned on September 21st, 2022. Defendant's bond was set as revoked by the arraigning judge. to be?
Your Honor, I'm just standing in for Michael. He will continue to be counsel. I am able to schedule.
So you're just standing in today for him?
That's correct. He had a prior schedule.
So, Ms. Haranek, so that I know what the state contends happened here, why don't you tell me? Tell me what you say happened.
So, Your Honor, on February 18th, 2022, the victim, Janine Castro-Vinci, and her live-in boyfriend, who is the defendant, got into an altercation prior to the victim leaving for work. Involved in that altercation, the defendant struck the victim in the face with her phone, resulting in an injury to her lip. The victim then left, went to work, where she worked as a bartender into the wee hours of the morning, which brings us to early February 19th. When she got off of work, she returned home. The defendant was still at home. They continued their verbal argument, which again turned physical. The defendant pulled her down by her hair while she was on the ground, punched and kicked her around the head and neck, and then she was picked up and choked against the wall of the hallway. And while she was being choked, the defendant stated that he was going to go to prison because he was going to kill her tonight. The victim was able to talk the defendant into letting her go. The victim then went, under the pretense of going to get a glass of water, went into her room and put her firearm in her pocket because she was afraid that if she tried to leave the house, the defendant would kill her. The victim did then attempt to leave the house. The defendant charged at her and the victim fired a weapon. The defendant grabbed the muzzle of the firearm as it fired and was shot through the hand. The defendant then tackled the victim outside through the open door into the snow, where there was a struggle over the weapon for some time before the defendant was able to get the gun away from the victim. The victim ran across the street.
Okay. Other than not guilty as to the allegations, defense want to say anything?
No, Your Honor. Mr. Capristo has entered a not guilty plea. He maintains that plea. The state has submitted a potential plea offer this morning upon arrival. I know Mr. Goldberg plans to review that with Mr. Capristo, but at this time, nothing further other than maintaining his innocence.
Okay. So what's the state's offer?
Your Honor, the state's offer would be to plead guilty to count 3, abduction of felony of the 3rd degree, and count 4, domestic violence, a felony of the 3rd degree. I apologize. Yes, count 4. The state would then recommend to dismiss the remaining counts at sentencing and would recommend a pre-sentence investigation and report. However, does plan on recommending some prison time.
All right. And Mr. Capristo, does the recitation of the offer just made by the prosecutor, does that sound the same offer that you have?
Correct, Your Honor.
Okay. And so you haven't had a chance to talk to Mr. Goldberg about that yet? All right. So the how much time do you need to consider the offer and talk with Mr. Goldberg about it?
I don't know what Goldberg's schedule is, Your Honor. Your Honor, I had indicated to Mr. Capristo that Mr. Goldberg would be able to be out here to see him no later than next week.
All right. Do you anticipate any pretrial motions being filed?
Your Honor, in discussing this with Mr. Goldberg, it was my understanding that there would be no pretrial motion.
No motion to suppress evidence? Okay. When can the state be ready for trial?
Your Honor, the state generally requests at least 2 to 3 weeks to give notice to witnesses, but
Okay.
the court sets the trial, the state can be prepared.
I don't have a time waiver on the case,
Correct. I did bring a copy.
so,
Your Honor, I discussed that with Mr. Capristo prior to Your Honor taking the bench. He indicated that he will not execute a time waiver. However, after speaking with Michael, it's something he may consider.
It's my understanding, Your Honor, just so the court is aware, that the defendant is here after having entered a plea in Cuyahoga County to a felony of the second degree and a felony of the fourth degree, but that Cuyahoga County has kicked out its sentencing on that case until our case has been resolved and sentenced. I'm not sure if that might factor into the waiver decision, but I just wanted everyone to get it.
okay. Is Cuyahoga County waiting for a determination on the guilt phase?
I have spoken directly to the prosecutor. Apparently there is a date set for the sentencing on the Cuyahoga County docket. What was told to me by the prosecutor in that case is that they were going to wait for the Lake County case to be fully resolved before then sentencing.
So if this results in a guilty, they want
sentencing.
Lake County to sentence first?
That is my understanding.
Your Honor, for the record, we are not representing him.
In the Cuyahoga County case? Who's representing him there?
The Public Defender's Office.
Okay. Is there an indication whether the judge there wants to make anything consecutive?
I have not had a conversation that in depth with
That that the judge which judge is it?
Your Honor, it's Judge Kenneth Callahan.
Ken Callahan?
Yeah, and there's a date set for November 7th, I believe. I checked the docket prior to coming in.
I can reach out to Cuyahoga County again and we can schedule a phone conference to go over whatever, if I find out
Okay,
more
I'm just wondering, I can see, well, maybe they don't want him sent to prison. What would he plead to down there?
As far as primary or?
No, what's the charge?
Charge is, I believe it was just a simple burglary.
My understanding is a full F2 burglary and an F4 disrupting public service.
Okay, so it's a Senate Bill 201
Yes.
burglary. Okay, so we will give you a quick trial date, and I'm not inclined to move it because Cuyahoga County is waiting for this case to be resolved. So if I'm in trial, I will give it to another judge who's not in trial, so that you definitely go forward. So I
understand.
I don't want to bind Mr. Goldberg, but I'm not binding him. His client is. And if his client is insisting on a speedy trial, then Mr. Goldberg's request for a continuance is just for Mr. Goldberg's convenience, and he can probably get somebody else to handle the trial. Perhaps you, since you're out here for the pretrial.
Your Honor, the whole thing was, I just haven't spoken to my lawyer. I'm not opposed to waiving time. I just want to talk to Goldberg and see what his thoughts are. And I know there is some evidence that we have to yet acquire. I don't know how long that will actually take to get. I don't know.
Okay.
The procedure.
Well, so you haven't seen the discovery yet?
Not entirely, no.
All discovery has been provided to defense, Your Honor, as of July 11th.
Okay. So you understand that you have a constitutional and a specific statutory right under Ohio law, and I enforce that strictly. And I'm willing to move things around. I'm willing to bring in another judge in order for you to get your speedy trial rights preserved. But then if I go and do that, then I'm not gonna, you know, have you jerk the court around, because if I get another judge here to do this,
It's not my intention at all.
okay.
Your Honor, if I waive now, can I will take that back at a later date to speed it up once?
Well,
I don't know how it works.
here's the thing. You'll get a speedy trial. You were only arraigned on Friday, okay? But your speedy trial time, it runs 1 for 1, correct? Or is it running 3 for 1?
We have it running 3 for 1. I don't know the answer to that.
Are you on bond in Cuyahoga County?
Your Honor, after he entered his plea and was transferred back to Lake County, K-Bay's position.
By Lake, or by there?
By Cuyahoga.
Okay, so I don't know whether it's running 1 for 1 or 3 for 1. And so I can't take any chances on that. So my feeling is that if you waive time, nothing languishes here.
My biggest concern is, Your Honor, I just don't want to sit in county jail for a year.
Oh, no, nobody sits in jail in Lake County for a year.
You know, I have. Your
Where?
Honor. The last time I was here, just to get the case dismissed, I sat
When?
there for a year to the day.
You were in Lake County jail for a
Lake
year?
County jail for a year to the day.
Okay, you're pointing towards Cuyahoga. Lake is over there.
Wherever, I'm not, wherever. I'm at.
You sat in jail for a
To
year?
the day, Your Honor, only to have the case dismissed.
Which case is that?
I'm aware of what case it is. I don't have the date. I don't have my computer with me to check the dates for me. I find that hard to believe because it was never even indicted.
Right, a year to the day.
So that I don't think there's any way that there would have been a year that would have gone by.
A year to the day, and then the day they dismissed. I know there was a bunch of stuff that went on with
Where did the case come from?
Wycliffe.
So the Willoughby Municipal Court?
Yes. I know there was an issue with, I believe, the prosecutor.
What
had a
was the
heart attack,
charge?
And then,
What was the charge?
it was an ag burglary.
Felony 1?
I
Aggravated
believe it's a
burglary?
felony, too.
I may be thinking of a different case. He also did have a domestic violence against this victim dismissed prior to indictment.
Yeah, no, it had nothing.
Oh, not that one. Okay, well then I'm not
Yeah,
sure.
it's totally something totally different.
Well, I need,
Either way, I just don't want.
I need to look that up. 'Cause so you're saying that Willoughby Municipal Court committed you for a year on a case
No,
that wasn't even indicted?
Right, they bound it over to the common police court, and until that time, the prosecutor, I think, had a heart attack, and then I want to say, Colson had something going on before everybody could sign off on the dismissal. Or at least that's the bullshit I was fed. Sorry, Your Honor.
All right, number one, I want to make sure you weren't there because of anything I did.
Absolutely not.
Okay, I just want to make sure of that.
No, I'm not trying to place blame.
Because we record the proceedings
No, I get
and we
it. I'm not
stream
trying to-
them, and I don't want anybody to think that I
No.
kept somebody who's not even indicted in jail for a year.
No, Your Honor, it had nothing to do with you.
Okay, I want to make that clear,
No,
but I need to see this because,
From what I understand, it was pretty much everybody but you. I mean, there was one, I want to say the prosecutor had a heart attack.
I believe
And then-
Mr. Geiger did have one of his prior cases with Lake County.
But it was just an ordeal where everything came one after another, and I just ended up sitting forever. I just don't want to have to deal with that. Whatever the outcome may be, that's all.
Capristo, do you know why the charge was dropped? It was filed as an F1, aggravated burglary.
The lady that pressed the charges, she lied about the whole case. The whole thing was, Your Honor, her mother told me to go check on her because she was a heroin addict. Well, she lets me in the house, I throw her dope in the toilet. She freaks out, calls the police on me, makes up this big story. So finally, she tells her parents that she lied, and my attorney at the time, Bobby DiCello, they all, I don't know how the parents got it on recording, that she admitted to them that they lied. So it was a bunch of crap that ended up being, you know.
So she just made it up.
Yeah, she was mad because I threw her truck at her. And she, after all that time, she finally admitted that she lied to her. She admitted to her parents. And Bobby, my attorney at the time, Bobby DiCello was present, and they had it all on recording.
All right. Okay, so I can
just don't wanna be stuck in that.
I can see your hesitance to sign a waiver of time. The problem with your case was it came from a muni court. They bound it over. They lost jurisdiction once they bound it over. So then it never got presented to the grand jury because they couldn't get a hold of the victim, or what?
I'm asking someone to look into it. I don't know the details of that case. I'm just asking if y'all to look into it, 'cause I'm not sure. I'm asking for dates.
I don't know the extent of the grand jury.
Well, I'll tell you what. And so I understand your hesitance. I'd be very irritated too.
It was a little irritating.
So how about instead of a blanket waiver of time, that you waive time for 30 days beyond what it would normally be?
I mean, Your Honor, if you give me your word that you're just not gonna drag me here for
No,
for a year, then I'll do it.
you're not gonna, no, you will not languish in this court. Certainly,
All right. If you tell me that, I believe you, I'll sign it.
yeah,
That's fine.
that offends me that, you know, you were in
I
that.
was kind of offended too.
So
I mean, I
we'll
realize I'm not
do a
the best
30
guy.
day, you have a form, right?
I don't have a 30-day waiver, but I can.
No, but write it in.
Yeah.
30 days
Yes.
beyond what the normal speedy trial would be. Since we don't know what that is, it's a limited waiver of 30 days.
You don't have to pen in the 30 days. If you tell me I'm not gonna languish, I trust you.
Well, I want to make sure that you understand being fair to you.
You've always been fair to me. You know.
I know that.
I mean, I hear.
I have that reputation of being fair.
Well, I don't know. I hear all kinds of stories about you. I gotta be honest. But anybody ever asked me, you've always been fair and decent with me, and I'm not gonna take that away from you at this point. So if you tell me I'm not gonna languish, I'll sign.
You're not going to languish.
Then I'll sign.
Go ahead. Then you get together with Mike Goldberg, mull over the offer and the evidence. I mean, you have to compare the offer to the evidence.
Correct.
And then let the prosecutor know what you want to do on that.
Judge, would you like to waiver?
Yeah, I'll take it. I'll file it. All right, anything further?
No, thank you, Your Honor.
Okay. Talk to you later. We're adjourned.
Your Honor, we're still gonna continue to be fair with me, right?
As always.
Thank you.
So well.
Thank you, Your Honor.
Take care. This is case number 22 CR 0000905, State of Ohio versus John A. Pomplis. Mr. Pomplis is in court, represented by counsel. Assistant Public Defender James Matthews, representing the State of Ohio, is Assistant Prosecuting Attorney Rocco DePiero. The defendant is indicted by the Lake County Grand Jury on September 19th, 2022. A total of 11 counts. Count 1, grand theft motor vehicle, felony 4. Count 2, petty theft, misdemeanor 1. Count 3, receiving stolen property, felony 4. Count 4, unauthorized use of a vehicle, felony 5. Count 5, failure to comply with order or signal of police officer, felony 4. Count 6, criminal trespass, misdemeanor 4. Count 7, theft from a person in a protected class, felony 5. Count 8, theft from a person in a protected class, felony 5. Count 9, possession of heroin, felony 5. Count 10, possession of cocaine, felony 5. And count 11, aggravated possession of drugs, methamphetamine, felony 5. The defendant was arraigned and entered a not guilty plea, and bond was set on September 22nd, 2022. And the matter is before the court for a pretrial. And Mr. DePiero, what does the state contend occurred here?
As a summary, Your Honor, going chronologically is per the counts in the indictment. The evidence would show that June 10th, the defendant took a car owned by Roger Saluco. And he said, "Hey Roger, your car's in tow, he's going to move it." Roger said, "Sure." The defendant took his keys, took the car, never brought it back. And then 6 days later, June 16th, the defendant is at Walmart bringing up merchandise. It's all about $22 worth of various small merchandise from Walmart, left the store.
In like one of the self-checkout?
Yeah.
Okay.
In the car. And activated lights and sirens to stop the car. Defendant was driving.
This Mentor Police, Eastlake?
Madison.
Madison.
Yeah. It was Madison Walmart. And it's Roger Saluco's car. Defendant does not stop. Not a long chase. We're talking about a matter of hundreds of yards. With activated lights and sirens, the defendant did not stop past 2 cars and ran a red stop sign to the left. And Madison Township did not pursue for their policy. So the F4 is the defendant was at that time committing an unauthorized use of an RSP motor vehicle, continuing with grand theft motor vehicle. That's the felony that he's immediately committing. That's the basis of the F4. It's not an F3. Hour or so later, people in Madison notice a car that's parked in an abandoned house. Call the police. Police go. This is the stolen car, Roger Saluco's car. The defendant is inside of a structure that is a separate structure behind the house. Then the thing comes out. Acknowledges he took the car. Does say that Roger Saluco gave him permission to have it initially. The defendant was arrested at that time, and he wasn't supposed to be on that property. That's the trespass. The defendant posted bond in Mentor Municipal Court on those, or I'm sorry, in Hazel Municipal Court on those charges, and he was out mid-June, mid to late June. July 5th, the defendant went to the home of old friends of his, Mrs. Smith and her son, the victims of these deaths were now living in a disabled that's sort of the course of what went on here.
And has the state conveyed an offer to the defense?
No,
Has the state provided discovery yet?
yes.
And Mr. Matthews, have you reviewed the discovery yet?
Yes.
And have you had a chance to talk with your client about the discovery yet? Okay, so that still has to be done.
Yes.
Is the case set for trial right now? No,
It is not, Your Honor.
because it was just a ring.
Our first pretrial hearing.
Okay.
Time does run November 3rd.
All right. So when can you be ready for trial?
I don't know of any times where material witnesses will be unavailable as I stand here, Judge.
All right, so if we gave you a trial date today, in a matter of a few weeks, you'd be able to be ready for
As
trial?
far as I know, standing here, we would. And
Okay.
if there was some problem, we would overcome it.
Okay. And the same with me. If I'm tied up with another case, I would just give it to a judge that's not trying anything so that it can be tried on time. And Mr. Matthews, you see any impediment to my enforcing your client's speedy trial rights?
The only impediment I personally have is I am scheduled to be out of the country from the 15th of October, returning, I guess, the following Saturday, which I guess would be the 22nd.
That might be a problem. Is there somebody else in your office that can try the case?
Can I say something?
Sure.
All right, so I'm gonna make a fast story about speaking here. Obviously, this is the second time you've seen me in the last 24 months, so that's not a good look.
Speak up a little bit louder. I'm having a hard
I
time
said
hearing.
this is the last 24 months you've seen me twice now. The last time I was in here, it was kind of the same situation with a guy who died. I left the syringe, and I just took the case, whatever. Now, as far as the running from the police, and Roger Lugo has a history of giving people his car. That's neither here nor there. It's not.
Hold on, be careful what you say, because, this is being recorded,
Absolutely.
and if you say something that can be used against you at the trial, prosecutor's going to use it.
Well, absolutely, and I'm not even trying to contend with Mr. DePiero here. I mean, he's been pretty fair and lenient with me on other cases, as is you. Now, in the situation I got going on with myself, I never keep a paper trail. I slipped and fell in the jail. I'm pissing blood. I got chip bones. They're not giving me any proper medical treatment. Cynthia Brooks, I subpoenaed a tape. Okay, I'm trying to not go pro se because they say if you go pro se, you're going to fool the client. Okay, get all that. I'm not even trying to contend the fact that I committed some of these crimes or I did not commit some of these crimes. What I am trying to do, though, is either get a reasonable enough bond to get out to get counsel. This is the first time in my life I've been sober enough to actually, from the last time I seen you, I've actually followed up. The heroin and all that stuff wasn't even on. I didn't even piss dirty from all this stuff. With that being said...
Wait, the drugs weren't found in his system?
No.
I don't know about any sort of chemical test of any bodily fluids. I'm speaking from the police report and the body cam video where the police find...
Okay, so we're not talking about any test where that shows he ingested any of this?
Not that I know of. I was talking about his admissions and what the
Okay.
police found.
Correct. And
All right,
prior to
continue.
Court, I got pistol whipped in the ramp. My teeth are chipped out. I got dents in my forehead. They were supposed to turn me away protocol to have a concussion. They did not. I just with Ronnie Caprice, there was bullet holes in his hand. Okay, so I know the protocol. So me being me, I just accept it, and I'm not. So my mom said, write it down, keep a paper trail. So I have documentation from the day it all went down, and I'm just basically asking you to throw the mercy. Like I don't want to. I even do GPS, whatever I need to do. I'm actually at a point in my life, and I have some other issues that I potentially help myself with.
of time if you're sent to prison.
Well, absolutely, but I mean, why would, you know, I mean, I'm trying to avoid all this, Mr. Lucci, you know? I just, I'm at wit's end here, man. I never speak up, and last time I spoke up, it helped because they lied, you know? So, like I said, it's not Mr. DePiero, it's not even the department. You know, he's been more than fair with me. Mr. Matthews has done what he's supposed to do, but again, he's got 97,000 cases over there. Nobody respects it. Yeah, I just need to do this on my own, you know? So I'm asking if you would give me the chance.
Mr. DePiero, what kind of offer would you make on this case?
I was speaking with Mr. Matthews prior to the pre-trial hearing. I don't think I'm speaking out of turn when I say that what the state is considering offering, this is not an offer, but what the state would consider offering is, there are a series of charges here that involve this motor vehicle. Grand theft motor vehicle, an RSP motor vehicle, and an unauthorized use. Two of those are an F4 and one of those are an F5.
They're different cars or they merge?
Same car.
Same car.
So, you know, the state would, in speaking with Mr. Matthews, I represented what we would consider maybe doing one of those. The F4 failure to comply. You know, those F5 theft from a protected person in a protected class, and we got separate victims. So, you know, these are. And then one of the drug counts, one of the three. Now, what I'm saying are just thoughts that I had that I spoke with Mr.
So
Matthews.
you're thinking, okay, one F5 drug.
Yeah.
Putting both victims in the same F5 theft.
I'd have to talk to them first, Joe.
All right.
But even considering maybe it was two F5s, you know, the F4 and then one of those three for the cars. So at the high end it's an F4 and the low end it's one F5. So it's either one F4 or F5 for the car. The F4 failure to comply. At least one, maybe two F5 theft.
And a drug F5.
And a one F5. And Mr. Matthews is, you know, as always, advocates strenuously for his clients and was asking me what our position would be. You know, the state would recommend prison, whatever we came up with. None of these are mandatory, that Mr. Campos said. You know, Mr. Matthews and I were just getting to the point in our conversation where we were going to discuss whether the state would offer some sort of a joint recommendation. I would not be inclined to do that. I know Mr. Pompous wants to ask for community control. Why should I make him agree to go to prison? But I'll say now, I gotta recommend prison.
Yeah, I respect it.
Okay. And so, that is in the realm of what the state is considering offering, but in our very primary discussions that I had with Mr. Matthews.
Okay. And bond is right now $75,000, cash surety 10%.
Yes.
If, what would the state feel about an OR backed with felony 4 with GPS?
Very concerned about that, Joe. And if I may.
Go ahead.
There was an in-court arraignment in this case, and the state recommended at the in-court arraignment that bond be continued at the amount that was set at the municipal court. And as I mentioned, the defendant was arrested in Madison, and he was given a $5,000 cash surety 10% bond that was posted on June 27th. And then the defendant failed to appear on June 27th for his preliminary hearing. Then the evidence is going to show he committed this theft offense on July 5th while he's out of his bond. Now, he was arrested in August when men are found passed out. state's reservation about agreeing to an owner cognizance bond. Judge Condon heard the arguments of counsel and saw fit to set bond at $75,000 cash or 10%. Certainly, Your Honor, the state acknowledges that.
And that was a reduction?
It was a reduction from what the municipal court judge had determined. Yes, taking into consideration the arguments of counsel. Certainly, the state considers that when a defendant waives his right to a trial and takes responsibility for crimes when he doesn't have to, that is a sign that he wishes to do better. He wishes to address the problem. And I understand that. When I have multiple felony offenses in a short period of time like this that are committed after he failed to appear, after he posted bond, I can't look at you with a straight face and say I'm okay with it. I wish I could. I can't. I'm being 100% straight up.
No, sure. I get it. Can I speak again on that, Mr. Shapiro? To you?
Well, the judge.
What's that?
Well, I wanted to speak again, but I wanted permission.
Go ahead.
Okay, and with that being said, I totally respect that, but again, these are alleged crimes. And I'm willing to waive my fast and speedy trial and work with you. Like I said, I have something very, well, if I got make FBI, you're a detective, used to be a detective, I know a lot about you, Mr. Lucci, you know? And I know I just don't know how to go about what I want to do. Like, I don't even consider it snitching because this is a kid involved. And every morning I wake up and I watch this Amanda Berry episode, and my conscience is eating at me.
Well, here, as far as that goes.
Yeah. Well, I reached out, nobody's coming to see me.
Okay, as far as that goes, are you familiar with anything that he's talking about?
No, Your Honor.
Did you want to send one of your investigators just to talk to him about that?
Well, I have no idea what the defendant is talking about. And I don't know what investigations are going on, what agency would be appropriate. Certainly, I would not be inclined to ask a prosecutor's office investigator to speak to the defendant. If he wishes to unilaterally reach out to police, and if they're going to listen to him, that has nothing to do with the prosecutor's office.
What police department would have jurisdiction what you're talking about?
First it didn't go on Madison. My mother was out in
Madison Township?
Yes, sir. Now, you see, my mom's not here. She usually is. My mom's very sick right now. It's just not good. Anyway, so then I reached out to Bell, and Bell said it's too time-consuming to move inmates around, which whatever. But Jacob Bell wants me to put it on paper.
So did you say you talked to Doyle?
I tried. He wouldn't even reach out to me. Then Butler came to serve somebody in the indictment and a subpoena for his phone yesterday, and I asked him if he would speak to me. He told me right. So I got to go to the tablet. So my mom sent me the civic.
Okay.
So
Does Mr. Matthews know what you're talking about?
Nobody knows because that ain't changed.
Okay.
This is the first time. I haven't even got
All
discovery
right.
yet.
So here's what I
That's all
suggest you
response. I go do what I need
do.
to
Talk
do.
to your attorney.
Right.
Tell him what you are in possession of, what knowledge you have, and let him think about it, talk with you more about it, and see if there is something that he wants to proffer, and see where it goes from
And I'm
there.
not even trying to get everything
But,
down.
you know, you can't, I can't force the police or the prosecutor to talk to you. However, your attorney will talk to you and see what you have and do it that way. Now, the issue at hand is, when's speedy trial run?
November 3rd is the last day.
Okay.
It runs November 3rd.
All right, so I'm going to have to set this for trial so that it gets tried within those parameters. And if I'm engaged in another trial, then I will find a judge that will, that is not so engaged and will handle the case. But if I go and reassign this case to another judge to do it, then I'm not going to entertain a waiver of speedy trial, you know, on the last minute, because, you know, why would I go through all that gyration for nothing? You know what I mean?
Well, I respect that, and I mean, what I waited for is to sit in county jail and stare at walls while my kids are better myself, and like a coffee $15 now. I mean, it's just
yeah, I understand what you're saying,
Right, and they're not
but
gonna
based
be-
upon what the prosecutor said, I agree with him.
Right.
You know, you're not a stellar client out there.
You don't say, huh?
No.
Yeah, but I'm not a killer or a rapist either.
Well,
You know?
but the public deserves to have,
The public likes
you know,
it.
a crime-free environment as possible. So, talk with your attorney. If you want to waive time, do it this week. And if you don't want to waive time, we will get it on the schedule, and it won't move, and I will find a judge. If I can't do it myself, I will find a judge to do it.
What about the medical stuff? Did they agree or not?
That's all the notes that you've been,
Well, I came out the shower and I slipped it down in front of the shower. There was no grip tape. You know, there was no wet bucket, there was no wet floor sign. So Bobby DiCello said, you have a lawsuit. I said, of course I do. But now when you try to call these numbers from the county phone, they're all unauthorized numbers.
what numbers?
Any defense attorney or any kind of civil matter attorney, you have to go three-way.
You didn't talk to your,
Well, I left the message.
no, you didn't talk to Bobby DiCello about it?
No, well, I had a third party do it, and he's busy himself, and then whatever Jewish holiday was yesterday, the day before, Howard Skolnick and all them off. So anywho, I subpoenaed Mrs. Brooks to get the access communication surveillance, because I did fall. When I talked to Elridge, I had cuts of them straight lying, saying that they did put the tape in on the 15th. They did not. Crim didn't come put the tape in on the 17th. So I went and had blood in my urine, and they said I had a UTI. Well, they gave me antibiotics. There's still blood in my urine. My vision is blurry. So I cut into Miss Brooks yesterday to see about getting outside.
Were you examined by the nurse or the jail doctor?
Yeah, and I'm going to show you that as well. You know, usually I don't push this, you know, but I mean, something ain't right. And on September 17th, I was in the range, and it said they put slippers with the man, some stuff, whatever. I have witnesses, and it says Elridge. There's also the black mold, so that don't really matter. Excuse my language. But the fact is that I slipped and nobody wants to help me. So then there's all documented on the tablet that they have in there, and they keep spinning me in circles saying it's a UTI. Okay, well now I took antibiotics for 10 days, and I'm not a homosexual, and I had sex with no man in jail. Where's the UTI coming from? 45 days in jail. So now they're trying to get. Well, we're gonna have a double mat. I've been in that jail, like you said, stellar client. You know, they never offered me double mat. I came in to beat the hell up, and I'm saying they want to give me double mat, which is very, very, very consistent with catering. And I need to seek out. Like I said, this is serious business. I am taking blood. I do have a chip though. I can feel it. My vision is blurry. I have a constant headache and address, and they keep giving me acetaminophen. I have hepatitis. I mean, Ray Charles can see that's the dumbest thing to do in the world. You know, so I'm not trying to be a smart ass, sweet language here, but I'm just at wit's end with what to do. And I was waiting to see you because, you know, I mean, like I said, me and you have a history. It ain't the best one, but it ain't the worst, you know.
Do you have a doctor?
I do have a primary doctor, Dr. Brendan Sailors, and he said, well, you can get out and see me because he was going to put me back under, I have neuropathy through my hands and arms. So he just prescribed me because I can't.
Well, if you have or can set up a specific appointment for him to address those issues, then you can file a motion well enough in advance of that for a furlough, but it's going to be under guard, and then I will consider that. I'm not promising anything, but I need to see a motion. I need to see a specific appointment. Go through your attorney. I prefer to go through the attorney because you're represented. Pardon me?
He's going out of the country, you know.
They've got other attorneys on it.
Yeah, well, maybe I'll get lucky and get John Fatica, you know. Yeah, right. Anywho, sorry. All right, well, I guess I'm done here, sir.
All right. Anything further?
No, thank you, Your Honor.
Thank you. We're adjourned.